For the Bar Council.
Venugopal, let me say we are beginning with live streaming, and you are one person who was always.
It's sheer coincidence, Lord Chair. In 2016, your Lordship had issued notice to me before I became Attorney General to assist the court as amicus, and therefore not say thought.
Oh, thank you. I, in fact, requested Mr. Vishwanathan also to assist us because. Yes, yes. No, after that, so that he had assisted us in another matter. We had appointed him as amicus to assist us in other matters. So I thought that matter had gone on parallelly. We thought we'll get the material of that matter also. And some directions we had issued to the Bar Council, which the Bar Council had complied with. With their consent, we had discussed how to upgrade the exam, how to improve the quality, how to improve in law colleges, how to have better verification, quality of papers. So, Nathan had given us a lot of details in terms of how in different countries, what are the concepts being done. Why should there be a negative marking in the examination of a quarter or not? So he's given us both point of views that we had, of course, left things to the Bar Council, but flagged all issues that you take a decision. So, in many aspects since then, in those proceedings, the Bar Council has taken upon themselves to pass various resolutions, and actually, in terms thereof, they had complied with uh, everything in terms of examining everything and taking a call. Ultimately, power vests with them. So I was just updating you on what has been done in the matter. That's why we wanted some of those orders to be placed.
We have placed that in the compilation.
Yes,
Milords, what I find, Milords, is an investigation, and I think my friend was very enthusiastic. He has prepared Mr. Siddharth Kohli a large bunch of documentation placed before your Lordships. But from the earliest 1923,
yes,
from the earliest year 1923, the Samuels Committee recommended that there should be an examination.
yes,
And I find that consistently, acts after acts which have been passed, or committees which have gone into this matter, the Law Commission report, without fail, have said an examination is necessary. Additionally, training also is necessary. And that, is contained in a list of dates which I given to your Lordships. But, 1923 was the Indian Bar Committee,
yes,
the Shamir Committee. And in 24, it gave its report regarding the grade of practitioners. In 1926, the Indian Bar Council Act 1926 was passed. That is item 3. And if your Lordships will be pleased to see, section 15C, the Act required the giving of facilities for legal education and training and the holding and conduct of examination by the Bar Council. Therefore, as early as 1926, in 1953, the report of the All India Bar Committee, headed by Justice S.R. Das, Judge Supreme Court, was published, and there your Lordship will see at the last 2 lines, or the last 5 lines, the committee concludes uniform minimum qualification for admission to the role of advocates should be a law degree obtained after at least a 2-year study of law in the university after having first graduated in arts, science, and commerce, and a further apprentice course of study for 1 year in practical subjects, for example, law procedure. The state bar councils should hold an examination in these subjects. Thereafter, in section 28(2)(b, after such training were omitted, I'm sorry, Lords. At page 2, the committee recommended the creation of an all-India Bar Council, sections including to prescribe qualifications and admission to advocates, to provide and make arrangements for imparting legal education, holding examinations for and training of advocates. In 1958, the 14th Law Commission report, if your lordships would come to my lords, the italics portion at the bottom, pages 103 and 115. Entry into the law colleges should be restricted to a system of strict tests so that deserving candidates are admitted. A person who has only a degree of law should not be permitted to practice the profession. A person who, after obtaining his degree, wishes to enter the profession should pursue the professional course conducted by the Bar Council in procedure. Those who wish to enter the legal profession should be required to work in the chambers of an experienced lawyer and maintain diaries. Therefore, my lord, so far should pursue a professional course conducted by the Bar Council is as necessary to be through an examination is what I would conclude. Because the training in the chambers of an experienced lawyer is separately mentioned. 1959, the Legal Practitioners Bill, my lords, was introduced. Clause 26, 2A. Yeah, clause 26, 2A. Course of practical training in law and the examination to be passed after such a training for admission as an advocate. Then 7. The Joint Committee of the Lok Sabha rendered its report. Committee considered that a course of practical training followed by an examination in regard to such training should be made compulsory. Therefore, there is absolute uniformity and like-mindedness in approach to this particular risk. Then, next page 3, section 24 to include practical training and examination to be conducted by the State Bar Council. As a consequence, the Advocates Act 1961, when it was enacted, if your lordship comes down to section 24, subject to the provisions of this act and the rules made thereunder, a person shall be qualified to be admitted as an advocate on a state road if he fulfills the following conditions, namely D, and this is the one which was later deleted and has given rise to all the problems. He has undergone a course of training in law and passed an examination after such training, both of which shall be prescribed by the State Bar Council. And then the Advocates Amendment Act, and if your lordship will turn over the page 4.
Just 1 second, Mr. Venugopal. Where in clause D we say that he has undergone a course of training in law and passed an examination after such training.
Yes.
Because one of the issues raised is, can there be a prescription of an advocate to work with a lawyer, and that's how all these judgments arose. And second, of course, is the bar exam. So nobody is now, I think, disputing the fact that the bar exam can be held, and the issue of enrollment and vis-a-vis the bar. What would be your view on clause D? How should it be construed according to you?
Clause D.
Yes.
But D was essential.
Yes.
Your lordship saying that uniformly from 1926 onwards, every single committee, every single bill, every single act provided for an examination and also training. Now, what had happened, and I have mentioned this in one of my lord's articles, the students went and started it, as a result of which Parliament reacted and deleted what was an essential requirement before a lawyer could be.
That's why I'm posing the question. Is it something which the Parliament should do, or is it something which requires construction by us?
No, but this will be one of the items, entries in the list, and therefore, so far as the Parliament is concerned, it would be entitled to pass a law.
No, that's true. The only thing I'm saying is, now having deleted it, what is the consequence? How can?
Yes.
Lord, may I submit one thing? Lord, for this, already, Lord, we have introduced the system of internship for the student right from the very beginning. they are required to be an intern under any senior, attend the court actually
That
procedure.
also called into question.
Notwithstanding the deletion.
I was actually wanting, what is the effect of the deletion, whether it is capable by parliament or is it?
No, Milord, the other provisions in the act read as a whole, in the scheme of the act, Milord, which I will take your lordship through in the note, permits, Milord, post-degree pre-enrollment exam, notwithstanding the deletion. The deletion would make no difference, is going to be my submission.
Okay, that's I want.
And there is, in law, Milord, the provision in the Advocates Act, read in the entire scheme and Milord, the specific provision in 49, permitting Milord the course of action of having an exam and a training. Will also construe the provisions, Milord, and the words used thereon and Milord the case law.
Milord, please see the,
And so there, Milord, is my submission, and I assume that's also the Learned Attorney General's submission is been wrongly decided. We'll be canvassing for its reconsideration.
That's what I wanted to flag. You are wanting.
Yeah.
Milord, there was a 3 judges bench judgment earlier to Sudhir,
To London.
where a doctor wanted to, along with his practice, be also practice law. And there they went into the whole of it. And they said expressly that on account of the other provisions in the Act, they, so far as the fact that this has been deleted will not affect either Section 49, which is Milord, the Bar Council of India's powers,
Yes.
or the central governments. And therefore, Milord, there is a specific provision which would be attracted. And that, Milord, was ignored by, Milord, the 2 judges bench of in Sudhir, as a result of which it becomes per incuriam. And therefore, we will take your lordships. But what your lordships should notice, if your lordships will go to D again,
Yes.
he has undergone a course of training in law and passed an examination after such training, both of which shall be prescribed by the State Bar Council. Therefore, what has been deleted is because the whole of this section 24, if your lordship will take that and see. Section 24. Subject to the provisions of this Act, subject to the provisions of this Act and the rules made thereunder, a person shall be qualified to be admitted as an advocate on a state road if he fulfills the following conditions, namely, and then find D,
It's been
which has been deleted.
deleted
In
in,
your lordship's book, it has been deleted,
yes.
but it is only, Milord, the examination after such training, both of which shall be prescribed by the State Bar Council. This will not in any manner affect any other provision, Milord, in the Act, which gives the power to, Milord, prescribed examination or training to, Milord, either the Bar Council of India or, Milord, the central government, which can make rules for that purpose. Then keeping this in mind, Milords, your lordships may proceed further. The Advocates Amendment Act at section 49, the following subsection at the next page were added. 8.4. The Bar Council of India may make rules for discharging the functions under this Act. In particular, such rules may prescribe AF, category of persons, therefore not advocates, who may be exempted from undergoing a course of training and passing an examination prescribed under clause D of subsection 1 of section 24, which should delete it. AG, the class or category of persons entitled to be enrolled as advocates. Therefore, my lord, the class or category of persons. Now, after your graduation, which is the class or category of persons who are entitled to be enrolled is a question. And there, my lord, the rulemaking power of the Bar Council of India would step in, and my lords, they would be entitled to, my lords, lay down the conditions, and this is what the 3 judges bench has held. Now, thereafter, my lord, the conditions subject to which an advocate shall have the right to practice. This will be, my lord, post his enrollment and the circumstances under which a person shall be deemed to practice as an advocate in a court. Then, my lord, section 49 capital A was added, which is a power of the central government to make rules. The central government may, by notification to the official gazette, make rules for carrying out the purposes of this act, including rules with respect to any matter for which the Bar Council of India or a state bar council has power to make rules. Therefore, instead of setting out the entirety of the rulemaking power, my lord, of the Bar Council of India and repeating it, my lord, in section, my lord, 49A, and the rulemaking power, my lords, of the state bar councils, the whole of it has been brought into, my lords, or subsumed into the rulemaking power of the central government. Now, therefore, my lords, whatever is contained in section 49 regarding the class or category of persons who are entitled to be enrolled as advocates was also a power which, under 49 capital A, the central government could exercise. And the fact that D has been omitted would not affect in any manner the powers of the central government, though, my lords, it is also the rulemaking power which the state bar council have. Then, my lord, 1973, the Advocates Amendment Act 73 was passed. Statement of objects and reasons. Pre-enrollment training. The Bar Council of India has decided that in future a degree in law can be obtained only after undergoing a 3-year course of study in law after graduation, as a result of which the age of entry into the legal profession becomes much higher than the age of entry in other professions. Therefore, felt that after a 3-year course in law, a university, it's not necessary to retain the statutory provision in the Act requiring a further examination or practical training. This, my lord, section 24(1)(d) was omitted, but that is only so far as the State Bar Council is concerned. It does not, my lord, affect the powers of the central government or, my lord, the powers of, my lords, the Bar Council of India. That will be the submission, and that's what is accepted by the 3 judges in their judgment. Therefore, my lord, so far as this is concerned, the submission is, this was a result, as I had stated, that of protest by the students who said we do not want an examination, we do not want the training, we have spent money in enrollment. But what has to be remembered is this: why is it that 500 colleges were all removed and, my lord, the recognition withdrawn overnight, one by one, one by one, one by one? Under it was, I believe, the Chief Justice Ahmadi who, yes, was at that time responsible for all of them being removed. Now, it is because they were substandard, and they were not more in the nature of teaching shops. They were, and at the time of inspection, the Bar Council of India may tell you, just before the inspection, they get together benches, chairs, and libraries and faculty, and have them exhibited in a big building. And then thereafter, one put boards. And thereafter, my lords, they give certificates to the students. And therefore, my lord, under those circumstances, it was essential that there should be uniformity to be brought about. All these will have to be equalized to find out as to whether the minimum standards have been maintained by the law schools. There are 1,710 after removal of 500. There are 1,710 Milords law schools today. Milords, during my time in 1952, when I went to a law college, at that time, Milords, this was the last resort because I tried to get into the engineering college. I couldn't, I failed.
That's good. That's good AD for this profession.
Oh, you first may not try your chance in the medical colleges. That was the one which was the ultimate ambition of any student who had graduated from the 12th. Thereafter, engineering. If you failed in both, the law colleges always had enough seats. You just go in and apply and take your seat. Now, secondly, my lords, after and during those years, unless you had a godfather, because there was no examination or even if there was no training, unless you had a godfather, you would start wandering around, especially in the rural areas. So far as they are concerned, for the first time graduate in law, he would not be able to find a senior before whom he could practice even in his official area or the rural areas. And therefore, it is only if you had an uncle or a father or a relative or a friend that you would be able to perhaps even get into the profession and be able to learn what is happening in the courts. Now, of course, with the national law schools and so on, the entire scenario has changed.
Some of the best students the National Law School has produced
Yes, yes.
the best students. So
I
it's
think,
become a changeover in terms of a priority. People leave other things and join law.
Today,
The
Milord,
option.
today the lawyers make mostly, other than perhaps in the rural areas, and they are quite well off. There was a report in 1984 by N. Madhav Menon. He had not been interested by the Bar Council of India to find out the status of the lives of lawyers in the Tamil Nadu state. And he went throughout the state. And he came out with a very depressing picture. So far as 1984, so far as most of the lawyers in the official are concerned, they were carrying on agriculture or other operations because otherwise they would not be able to earn enough. And the average income was 1,000 rupees a month, which is perhaps the BPL level practically. And therefore they resorted to doubts and they resorted to illegal practices, some of them to get some amount of practice. Now all that is gone. Today, the law colleges stand on the same footing as medical colleges or engineering colleges.
Mr. Venugopal, one caveat. See, when we talk about the national law colleges, that is the position. You yourself said we have many colleges spread across the country. There is no consistency in the sense that, say, Tamil Nadu has one of the least number of colleges.
The Ambedkar College is very good.
But if the number of colleges are still small compared to
Yes.
you go to some adjacent states and suddenly the jump is 10. Some of them, I think UP has grown 50, the population is there. So the issue is that possibly it's a question mark always, I must say, that where is the teaching staff coming from these? Do we have so many teachers or not? Some of the lawyers do part-time teaching. And my impression of the states I have been in the rural area still, it is a part-time profession, often. So people are practicing law and carrying on some other work also to supplement. So, yes, a section of lawyers are doing undoubtedly best and you're getting the best of talents and they're making the best of money more than anybody else, I think. That also is there.
Some is some.
But there are sections of this country, large section, where lawyers feel it's a challenge. Those first generation lawyers have come up, there's no doubt about it. And a lot of them is spread in.
From the rural areas, there are brilliant lawyers.
Some of them are
Except that their education in the lower classes are in the local languages.
that they make up.
And therefore, for them to be
We
fluent
have,
in English,
I can say, eminent judges whom I respect who came from a local language school and have done phenomenally well.
I was told that Justice Ramana came from a rural area. Many of the judges in the Supreme Court also perhaps have started life in a rural area, but then they have shown their special talent and competence. But therefore, so far as this is concerned, there are still, other than the national law colleges, each one of them, and I believe that there will be a judge of the Supreme Court, perhaps as a visitor, in each one of those colleges, which puts them, the vice chancellor, on their toes. And there are very good colleges like Chief Justice or various colleges.
On an update, Mr. Venugopal, I had gone to Patna in the judicial exam, judicial officers which I addressed. Almost 300 plus come from a national law school in Patna, Chanakya.
Chanakya.
Basically, I would
I
credit
have a
them with,
doctorate, my lord, from Chanakya.
I found an interaction during a
Yes.
extremely articulate and knew what they were doing. So there is a, I think, a trend even in judicial service also of people accepting more gender friendly now. Most of the places, one third are women. Delhi, women are more than men in recruitment. So there is a changeover. It takes a little time. But
Lord, the Supreme Court of India has put in tremendous efforts to upgrade, my lord, the standards of lawyers. And your National Judicial Academy and the State Judicial Academies, which are manned by Supreme Court judges and excellent lecturers, teachers brought from all over. And therefore, my lords, we are improving, but we are a vast country. And the Bar Council of India used to say that we had over 1 million lawyers, second to the USA, but now after some voting to find out, after they eliminated large number of bogus lawyers, I think the 5 lakhs have been weeded out. What is the remaining? How many are there?
7.5 lakhs.
Seven?
7.5 lakhs.
7.5 lakhs.
Are there from
Yes.
1.5 million?
Yes.
1 million.
I remember on judicial side in Chennai, Bakran is there. We had directed an exercise to be done of verification of lawyers. Also, sometimes you have a bar exam. The problem is there was no methodology by which if somebody doesn't clear within 2 years and he is already practicing, he would continue to practice irrespective of whether he cleared the exam. There are various nuances of it.
Therefore, my lord, today the picture has changed tremendously. So far as when I was studying in a law college, we had only the rookies to study. If we are able to master 64,
It is an esteemed book, Mr. Nandagopal, which has produced many prominent lawyers of this country.
200 pages of Saman was reduced to Millard's on jurisprudence, was reduced to 64 pages. You studied that, question would come from the examiners would look into this also. And if you knew your whatever was there in the 64
I'm
pages,
told it was called a dukki because it used to cost originally 2 rupees. That's how it is.
therefore, now today, and there was only a one way, that is the lecturer would be a part-time lecturer. He will be a lawyer. Therefore, one day he would teach Transfer of Property Act. The next day he would teach me Millard's criminal law. I mean, therefore, there is no specialization. And therefore, in those circumstances, the lawyer who passed out would be of highly substantive. There are no moot courts, there are no seminars, there is no internet down from which they could download what is the law in other countries or whatever it is. And it was something which was very basic. But today, the picture has changed here remarkably. Now, if you may continue this. Therefore, 1973, they held, and I said on account of protest by students, they say that after the last 3 lines, after 3-year course in a law university, not necessary to retain the statutory provisions act requiring further examination, and that is how 24(1)D met its end. And I think that is a highly retrograde step. Section 28(2)B was omitted. A committee for legal education by Justice so recommended the entry to the bar to be allowed after 12 to 18 months of apprenticeship with an entry examination. The recommendations. But today, statutorily, internship has been provided for by the Bar Council of India rules. And therefore, my lord, each one of us lawyers, we have, my lord, interns, 2, 3, 4, who every month they'll not come, especially during the holidays and intern. And they'll be given the briefs which we are going to argue, and they come to court, except that today, nowadays, I'm told, on account of security reasons, they're not allowed. But I think it will be a great thing for them. In all the high courts, of course, they'll be allowed. And but now, Millards, with what is it? With your No, no, with your, video, live streaming, your, they would be able to participate. And that's a great thing. But it is restricted, I'm told, only to the constitution benches. But
So far, it's the beginning.
it's a beginning.
Venugopal, it's the
And
beginning.
therefore, it should cover everything. And Gujarat High Court has been live streaming the Chief Justice's court on the for a year or 2 years. Huh? Yes, yes. I'm told that Justice Vikramanath has started it.
Yes.
In Gujarat. And we can just watch. I can watch the House of Lords, my lords, or even but the US Supreme Court, unfortunately, the technology is very backward because they only broadcast it so that you can listen to the arguments, but you don't see it live. Therefore,
But if this is what, many things could happen. Question was whether they should be live streamed also.
then, belongs 1994, AM Ahmadi Justice Ahmadi Committee.
Yes.
The chairman and UGC in 1926-9 wrote to the Bar Council suggesting BCI must hold an examination of the 5-year course with a minimum percentage of 50 to 60% prescribed before one could. Therefore, the UGC took it up. Then, though the State Bar Council exam had been cancelled, a plenary meeting of law ministers and law secretaries held in Hyderabad discussed reforms in legal education and entry into the legal profession. Meeting recommended that admission to law college should be through a common entrance exam. It also recommended a 1-year apprentice exam should be introduced in state bar councils. Then the newly added rule. Your Lordship, come to Milord, 1995, item 15.
Yes.
The Bar Council of India Training Rules 1995 was made. No person shall be entitled to be enrolled unless he is eligible to be enrolled, as such under Section 24 of the Advocates Act, and has undergone training as prescribed under these rules. However, while undergoing training shall be enrolled provisionally as trainee advocates. After approval of the name of the guides by the State Bar Council shall issue identity card to said provisionally enrolled trainee advocate for their identification. Then 21-10-1997, BCA wrote to the registrar of all the universities imparting legal education in India, stating that practical training was to be given to a law student prior to his getting a degree of law from the university. Then, my lord, comes today, but I have omitted, my lord, the 1996 judgment. This is 1999. Therefore, I take your lordship with the judgment which has upheld the powers of the Bar Council of India examination.
Because of which you say this is for inquiry.
So this is for
It is not considered.
if I should have put that in here. The 1995 training, it becomes at once clear that the rules are said to have been framed by the Bar Council of India in exercise of its statutory powers under Section 24(3)(d). And then, my lords, they finally hold in the last 5 lines. Must therefore be held on the express language of 24 subsection 3D that the rulemaking power of the Bar Council of India proceeded only in one direction, bringing into the sweep the section 24(1), all those who were not entitled to be enrolled as advocates in provision 24(1)(d). But here what is omitted is, it is only a restriction on the state bar councils.
Yeah.
It left untouched the powers of the central government to make rules and the powers of the Bar Council of India to make rules. Then, my lords, the Parliamentary Standing Committee released 85th report, lost delay, arrears report, recommended BCA should be given more teeth to implement these recommendations with respect to legal. They should have restored 1041D. They wanted report legal education, professional training, and proposals for amendment. The Advocates Act 69 and University Grants Commission recommended reintroduction of training and bar examination by the Bar Council of India by amending the statute. The advocate so-and-so has introduced in Parliamentary Amendment Section 7 to provide for pre-enrollment training and Section 49 to provide for conduct of a bar examination. The Supreme Court in the instant case noted that the entire future of the legal profession depends on ultimate product of these law colleges. Looking into the gravity of the matter, he requests the learned Solicitor General and the President of the Bar Association Chairman Bar Council to look into the matter seriously and submit a report to this court. Three-member committee, their suggestions received stating that there should be a two-tier system, purpose of ensuring that only the best students have the privilege of practicing law. For this purpose, only providing the minimum standards for the purpose of affiliation of a law college with BCI may not be sufficient, and an entry-level examination for the purpose of enrolling with state bar councils may be the need of the hour. A bar examination is a precondition for admission to the bar in most Commonwealth countries, pages 687 and 690. The introduction of a bar examination would ensure maintenance of standards as well as standardization of constant innovation in the standards of curriculum, teaching methodology. In light of V. Sudhir, such a requirement may be introduced by means of a statutory amendment. Then, Your Lordship, may Part 6, that is section, Your Lordship, may omit the next. That's posting. It was provided the rule 9 to 11, part 6 was added, providing for an all India bar exam stating no advocate enrolled under section 24 shall be entitled to practice unless such advocate successfully passes an all India bar examination conducted by the Bar Council of India. And this is post-enrolled. No advocate enrolled under section 24. The Supreme Court referred the matter to a larger bench. We accordingly refer the matter to a 5-judge bench for consideration determination for the following 3 questions. Whether pre-enrollment training in terms of the Bar Council of India training rules framed under section 24(3)(d) of the Advocates Act to be validly prescribed by the Bar Council of India, and also whether the decision of the court in Sudhir requires reconsideration. Whether a pre-enrollment examination can be prescribed by the Bar Council of India under the Advocates Act 1961. In case questions number 1 and 2 are answered in the negative, whether a post-enrollment examination can be validly prescribed. Then subsequently in 2017.
Just pausing here, this issue of whether a pre-enrollment examination can be prescribed, one of the issues arose that with how the entry in the bar is to be made. So now in terms of Vishwanathan's suggestions, the Bar Council has passed saying there are 2 levels, 2 different registers to be maintained. When you clear examination and you are desirous of bar examination, there is separate entries. Where it is separate, so it helps in monitoring. And we got over Sudhir by some methodology. We said that interpreting Sudhir, that this is not what the intent is. So you can have a post exam, but they were concerned that if we don't enroll them, what will then how will Sudhir enter? So some solutions were found.
There'll be a lot of heartburning. You practice, and you're seen by the clients, you're seen by the judges, and then you're failed in your exam, and you discontinue as an advocate. That will be the accumulating experience.
Sorry, General, the difficulty is this. The Advocates Act is very different from the Chartered Accountants Act, Company Secretaries Act, Cost and Works Accountants Act. And there are other problems in those acts. The second issue is with regard to the level of education in India. That's a bigger problem, much bigger problem. And the difficulty in that is there are some excellent educational institutions at the higher level. And then we have a large chunk where probably you ask them even to write a letter, they will not be able to write a letter, or their communication skills, etc., are very poor. The third problem is the number of cases we have. We require sizable number of lawyers. We can't, like, I'll give you, yes, I'll just give you the figure with regard to the lawyers is probably 13 lakhs now reduced to about 7.5 lakhs. We induct any where I think the total number being enrolled every year will be about 75,000 or maybe more. The total number of active practicing chartered accountants in the country is 1.5 lakhs. And we have a litigation today wherein the Chartered Accountants Institute has prescribed that you cannot do more than 60 tax audits in the country in a given year. Each chartered accountant. No. That's not the reason. The reason is that the tax audit, you take the responsibility of verification of facts. You are liable then.
It was earlier only 20 crore.
No, it was 30,
Now,
45,
subsequently now 50.
now 60 or 50. Because you have to verify. You are responsible because you do the verification. If it's a false verification, you are criminally liable. Or penalty is. So there are various difficulties. Look at the, I don't know whether we have the figure out of 7.5 lakhs. How many are those who are in actual active practice, who file their returns? I don't think they'll be having details of returns filed by any of these 7.5. If you get the income tax returns, you'll know exactly what the person is doing.
I had appeared
The
there.
lighter side may or may not reflect. Looking the legal profession, but I don't know whether there's ever a study done. See, one aspect. I'm saying how many lawyers does the country need? Just volume of litigation tendency is not issue. I find there are a lot of lawyers also without work.
Yes.
So this is a ramification also at times. Are we producing too many lawyers? Are we producing less lawyers? Some study needs to be done, maybe by the Bar Council or some authority, to see that looking to the pendency, and you can't look to so many lakh pendencies or so many lawyers, because that's not going to be. Looking to how many cases the court is able to take up across the country. What is the strength of the lawyers there should be optimally? Because the Bar Council exam, with all respect, I mean, you pass them with grace marks, you pass them with some other marks, you try to create, and it is so simplistic in character. Therefore, that is the matter we examine in the case. How to, fine tune. Have some easier questions, some more difficult questions. People should not be randomly just sticking on this thing because a negative answer, 1/4 negative mark, as in some examination, provides a solution. He also gave that there are some other places where they say no negative mark, it should not be there. It has to be structured to our needs in India, where most exams, to my mind, keep this 1/4 negative mark. And all MBAs and all other this thing, so that somebody is not getting marks by fluke. And if he, suppose he's not able to answer, he starts sticking.
About 15 years back, I appeared before your lordships, where the Bar Council of India at that time had sent out questionnaires to all the lawyers to answer on the various status of whether income, how many cases, what is your mother tongue, how proficient are you, and so on. The writ petition was filed in this court, challenging beyond the jurisdiction of the Bar Council of India to issue this, and finally nothing came out of it. Otherwise, you would have had there.
But was there a stay by this court?
No, it was not
Stay by
stay,
the court.
but I remember arguing the matter. I don't know what the outcome of it was.
Still pending.
The matter is still pending or the issue is still pending?
But the issue is also pending because the certain provisions are under challenge. We need certain amendments in those rules, verification rules. Actually, we were assisted by
Mr. Venugopal.
Mr. Venugopal only in that case. He appeared for several times for Bar Council.
How many years back was it?
2015, sir.
15 years ago.
If there was no stay, you could have proceeded.
If
Normally, you feel that the court should not impede in your working. And then the court doesn't impede in your working, you carry out the task.
Actually, in the meantime, elections of several state bar councils.
That's the problem.
And that is why the process.
That's the problem.
Stopped. Huh?
Therefore,
Now, my lords, I got only 2 more days. That is, my lord, Section 7(1) of the Advocates Act to provide for the
Just 1 second. Where Mr. Vishwanathan was appearing and suggestions were made,
My lord.
a lot of them were implemented, I think, by you.
Yes, yes.
But some things are awaited.
My lord,
Some aspects, but I think-
for those matters, we are seeking the nod of this honorable court, some direction from this honorable court.
We had given in that matter practically all directions. I think we only review what you do to see to what extent are your problems.
Committees are examining, post your lordship judgment, the honorable.
Therefore, that was my impression, that some aspects you said you have referred to committees, those committees will submit a report before we put a closure to that matter.
Lord, that committee we constituted, Mr. Justice Naveen Sinha committee has already submitted the report.
Okay.
We are
We'll try to
proceeding.
see this. Mr. Venugopal, we'll also try to find out the fate of that matter,
very well.
which is pending.
Perhaps it should
Whether it
be.
is a 2 judges, 3 judges, whether, what can be done with that?
It's listed.
Lord,
Only one difference, Lord. That was argued on the premise that the exam was valid and how to go about.
I understand, I'm not talking about that exam.
It has nothing to
I'm
do with
talking
it.
about the ones,
This matter, sir. Gujarat.
Oh, Gujarat, no.
no, that's a different area, therefore we are not.
But in that, your
taking-
lordships have given several directions for the general welfare of the profession
We expanded the scope,
and to increase the standard of the bar.
but I'm talking about the matter with, Mr. Venugopal was mentioning.
Or the verification matter, verification. Lord, we'll give the number, we have the number.
Let's keep the number, Courtmaster. Just check, Courtmaster. Just check up what is the fate, where is it, where line body is. We will give the number. You give.
My lord, I'm possible.
Mr. Mishra, just tell us one thing.
When you read it
Do
out.
you have independent figures with regard to the number of advocates enrolled in different states? Obviously, that will be.
My lord, that is there.
But then with regard to bifurcation, the number of advocates practicing before the High Court, the districts, different districts,
That's also there.
that's also there.
That's there.
And number of advocates who have put in number of years of service or in years in the profession, that may not be there.
Look, that is there because on the state enrollment, the year of enrollment is already there.
It's also available.
My lord, that's there.
And perhaps, my lord, say income with the declared minutes for income.
That they will not.
No, with the declared to income tax.
You see, I
We are at stages when,
I
later side, the elevation starts coming up.
No, we want to know.
And
whether-
suddenly income starts going when people want to get.
in fact, probably it's not been, it should be promoted with something which will not happen. 44 AD is a way, virtually you get up to 50% of what your gross receipts are can be claimed as an expenditure without maintaining books of accounts. Except the gross receipts. This is applicable till if your gross income is say till 50 lakhs.
But
So if you are even in 33% bracket, you're virtually paying 16% tax on your gross receipts. That's fairly, very reasonable. You can't, nobody can say
And
it's,
today, my lord, the Indian level of
it's very
is
reasonable.
much lower than
It's,
other.
and if you are even then, if you are in the bracket, lower, slightly lower bracket, many of the district court and other lawyers are, they're paying virtually 10 or maybe 20% tax, which is very, very low, which is compared to our general,
We can at least know, my lords, as to how many of them are
Correct.
not paying income tax.
correct.
That's also an issue.
They are below that very low level.
Correct.
Why should they disclose that? That's.
No, so that emulative millets,
No,
I think they don't do it.
steps can be taken.
This is the problem. That
Yes.
reflection of the incomes all over, and this is not only in legal profession, but legal profession traditionally, known and better, there has been a tendency to
Yes, not to
it's
disclose.
not
your entire income.
to. I wouldn't say pay taxes. That may be offensive. To not the receipts of our nature, which they would not like to declare.
But it's worth knowing millets as to
It's a
how
process.
many are living below the income tax payment level. That they are unable to get even enough money to, most of them, that is what Dr. Madhav Menon's millets report showed. Most of them, they are going to the fields, depend upon the income from
But
the
today,
agriculture.
when I can say when at the High Court level you consider for elevation, people who have, you perceive as a large practice, you start seeing the income criteria, it's a problem.
Not in district and taluka courts, the condition is very worse.
So therefore, this study which I mentioned, then how many lawyers do you need in the system? It is also happening because there is little work and it gets distributed. Of course, some people will have more work, but there is limitation on how much work a person can do by the number of hours, by the physical strength. So ideally, if work was reasonably done, how many lawyers do you need to assist the system? CAs, of course, restricted very minutely, but possibly the study will help you in determining
Malam.
also the level of the examination which you need to keep. Is it required to have so lenient examination? Is it better to have a little more tailored examination where the difficulty level is slightly more? It will be assisted by this data which you may have. So think about working on this thing.
Lord, we
Of,
can constitute a committee for that.
How many, you see, you can have how many cases are listed in a year, how many different district courts. How many lawyers would be required to deal with those number of cases? Today, the technology is such that this is an aspect which should not take long for you to determine.
Malam.
Because when COVID truth came out, in many taluka places, ration kits were required to be distributed to the lawyers.
Malam.
They could not survive. It's a situation at a grassroots level.
That's the harsh truth, you tell them. So, Lord, this number of lawyers required, not today,
It's an idea, just think about it, how to get it done.
Yes.
Maharaj, we'll do it.
Millets, I had letters from the young lawyers of Jammu and Kashmir. They are complaining that senior advocates extract work from them, but don't pay them anything. I think that's a grave tragedy. I forwarded this letter to Mr. Manan Kumar Mishra. I told him, why don't you set up a committee to go into this question as to whether the bar council.
Senior lawyers sometimes think it's a privilege to permit somebody to work with them. That used to happen earlier, Mr. Managopal. You are quite aware. Things have changed. Otherwise, one stage it was that it's a privilege to work with somebody.
Because otherwise,
You're right. If people come from backgrounds which are not financially sustainable, then after an education of 3+3, to sustain themselves for another 4 or 5 years is a challenge. And that is why I used to think that a lot of people, bright people, were lost to the profession earlier because they did not have the financial wherewithal. Go on for another 5 years with the family supporting them till they're in a position to earn. Today's situation is different. But yes, in smaller places, the problem will be more. Fee structure, Mr. Managopal, is very different in a smaller place than Bombay, Delhi, and Supreme Court. That's another issue.
no, but I think the bar council of India should not perhaps.
My lord's order, one of the issues directed is the placement, where my lord, the bar association will call for billing seniors, billing juniors, and that is made an incentive for elevation, designation,
Yes.
or my lord, empanelment even in public sector, unless that is made compulsory, my lord. Sanction you cannot do it because you can't force it.
That's
So
what you had
incentivize,
suggested, that
my
time
lord,
to incentivize it.
and a reasonable stipend. We were lucky, Mr. Venugopal, my lord, first of every month. And he was very particular that it come out on the first. So green check leaves we have to be ready on 31st. And something which could sustain us when.
I didn't have the privilege of working with him.
No, he was a brilliant lawyer from the very beginning. Therefore, he didn't need any financial support. He had his own clients. But therefore, I think there are two issues on which the Bar Council of India could press think about. One is it possible to incentivize seniors to some or other allow not the juniors who are assisting them to have some reasonable means of sustenance? Because many of them coming from the rural areas and so on, they may not
That,
have
Mr. Venugopal, I think they are taking it up. And in the other matter also, we've issued some directions.
Yeah, that'd be great, Milords.
To work out these things, how it can be done, how. So that one committee, that's why we've kept that matter like a continuing matter to just monitor and help them out in performing their duties, I would say.
And secondly, a rule that the question has been sent, they have to be responded to. Not that they can have any.
So that they can implement. If there is no stay, therefore, I'll check up what the position of the file. If there is no stay, what prohibits them from mere pendency of a matter doesn't mean that they stop doing it.
I think a lot could direct.
They would, they will have to have a little courage to do that. That's all.
This was because of the training rules that people were breathing out.
Find out what the
Very.
Maybe we have to see those orders. What prevents them from doing it.
Given the number of,
you're getting the one. I'll see it at lunch.
Would your Lordships now take it to SAC?
Yes.
On section 24. Persons who may be admitted as advocates in the state road, subject to the provisions of this act and the rules made thereunder, shall be admitted as an advocate in the state road if he fulfills the following conditions, namely, and there may not, he has been admitted,
Yes.
and he reads, and we have it may not extracted at page 3. Section 24, D at grade 3. He has undergone a course of training in law and passed an examination after such training, both of which shall be prescribed by the State Bar. So far as the State Bar Council rulemaking power is concerned, and if you're not, go to section 49. General power of the Bar Council of India to make rules. The Bar Council of India may make rules for discharging a staff, and in particular such rules may prescribe, and your lords may come down to AF, which was introduced, my lords, in 1973. The minimum qualifications required for admission to a course or degree in the recognized institution. And AG is what I'm concerned with. A class or category of persons, not advocates, entitled to be enrolled as advocates. Therefore, in deciding on the class or category, you can say that you have to fall into the category of persons who has passed an examination. And that's what the three judges have done. Now, the next one is a condition subject, that is AH. Condition subject to which an advocate shall have the right to practice, and the circumstances under which a person shall be deemed to practice. And therefore, post-enrollment exam can be brought under this. Therefore, the Bar Council can make rules, both milords for pre-enrollment examination or post-enrollment. We contend, my lords, that after the internship rules, this training, my lords, under lawyers may not be necessary because what they're getting through internship is far superior. Now, your lords may
Mr.
go-
Venugopal, just come to 49.
49 words.
Yes.
Yes.
AF. AF talks about minimum qualifications.
49A.
Yes, AF. Minimum qualifications required for admission to the course of degree of law
Yes.
in any recognized university.
Yes.
So that is at the stage of admission.
Admission.
Then AG talks about class or category of persons. Will the class and category of person means educational qualification also?
No.
No, it will not.
All other things which go
Correct,
to make
correct,
up a lawyer.
correct, correct. So it means class or category of persons entitled to be enrolled as lawyers.
Yes.
Then when we come to AH,
Yes.
the conditions subject to which an advocate shall have the right to practice and the circumstances under which the person shall be deemed to be practiced as an advocate of a court. So when we rightly pointed out, there's a difference in language. AG talks of persons and AH talks of advocate.
After enrollment.
Yes, because you will not be an advocate till you're enrolled. The conditions subject to which an advocate shall have right to practice. Can we interpret it as saying that a person who's already enrolled as an advocate need not be allowed to practice until unless he satisfied the conditions?
According to me, it could. Now, both.
That's the only line, Mr. Venugopal, which I feel can be taken.
Yes.
That, the requirement of post-enrollment to be able to practice possibly have to read, as my brother said, under AH.
Yes. Yes, my lord.
Age talks about conditions
Yes.
can be imposed by rules by the Bar Council of India.
Yes.
In fact, clause E of subsection 1 of section 24
Yes.
also gives some similar power to the State Bar Council.
Yes.
Clause E, which is not deleted. Clause B,
Clause C.
clause E of subsection 1 of section 24.
24.
A similar power vesting in the State
Yes.
Bar Council.
Yes, obtained a degree in law.
No, clause E of section 24(1).
To fulfill such other conditions as may be specified in the rules made by the State Bar Council under this chapter.
This is somewhat akin to clause AH.
Yes. Yes, that is true. No, therefore,
The equality,
one conclusion which-
exam is the biggest equalization process
Yes.
and an appropriate level of examination. You are talking about fluent and other examinations, despite people coming from different boards, entering to the university. The whole philosophy behind this, I presume, is that you are on one page or one standard. So the variation in standards, when you're talking about variation in standards of education between different law schools, that exam to some extent provides a minimum standard and is a reflection of the minimum standard required before you can be permitted to enroll in practicing. That is an objective. Now, therefore, the concern always has been with me that it should not, I'm aware that despite the exam not being a very tough one, the passing rate still is not very, very high. But that's not the objective. The objective is to see that it should be of the adequate quality to determine the competency to practice. Now, whether 10% clear rate or 50% clear rate should not be the benchmark.
But if in an all India examination, the results of one college shows that 60% of the students have failed, then one would think twice before continuing recognition and transfer whatever students to the other colleges. You have to have some weapon in your hands to ensure that you can't have a fly-by-night
That, as you said,
law colleges.
if you have a requisite level of examination in the Bar Council examination, then that itself can be indication, as you mentioned, to judge the performance of that. May not be the only, because sometimes they may come from more rural background, they may come from different. But there must be some minimum benchmark. Let us say in a Bar Council exam, people appearing from that college say not even 10% pass, then there is a problem.
Yes.
So that is actually can also be a material or input to the Bar Council to look to the performance of the colleges. Is it only when they inspect something happens? Or is otherwise something else happening also?
No, therefore, instead of withdrawing recognition, you may ask them to improve their standards by getting better faculty and ensure.
Biggest challenge is the faculty. They are not enough teachers. They are just not enough teachers.
No, so that
There
you
may only
again.
be some lawyers part-time teaching and thing. I mean,
I found a part-time teacher. He's, I think, a man of all talents in the sense that all subjects can be taught by him. One day he teaches.
I'm told at least in Madras there were many people on the bench. I know in Delhi also there were many
young
people
lawyers,
taught in the law college at some stage.
Young lawyers
also-
used to go and belonging to a particular party in power. I know as a fact, in which case you would be able to get a part-time teacher's job. But that cannot be the test. But if you pull them up because of the results. But Ambedkar College, according to me, has very good standards.
That has produced.
There's an old Madras Law College who had principals lots of great, where the students used to revere them. And we had lecturers, senior advocates, Sri Venkata Subramanian. The students from different classes would come to listen to him when he lectured on constitutional law. And because he was a tremendous teacher and had a huge knowledge of, he has appeared in the Supreme Court also in some cases. Therefore, we had at one time teachers also of great, even part-time teachers of great work. Now, therefore, the Bar Council should, I think, perhaps supervise
In
or
Delhi, I know at least,
monitor.
I can straight away recognize at least 3 eminent judges of the Delhi High Court who are all part-time. Rajdev Mishra, Justice A.B. Rodgi, this is T.P.S. Chawla. All at one stage in 50s. taught
They
part-time.
could be very good teachers. They could be very good.
Chandrasekhar was a part-time teacher in government law. That's all.
Justice Sikri taught. for
I'm
part-time.
told this is secret. My grandfather has wide knowledge. He told me this secret.
I missed out. He was the contemporary there for me. I missed out, but among the seniors, so it used to be a regular feature. Then slowly,
Is it permitted today? No.
yes.
Is there?
Last 2 months, we have amended our rule, legal existing rule. Even the sitting honorable judges of the High Court, Supreme Court, or even the lower judiciary, they can teach as the guest lecturers.
See, there's a, for example, Mr. Rangaba, Trichy will know there's a national law school set up there, and I was monitoring it. The problem is that there is no easily faculty available. We held interviews after interviews, and on some specialized commercial subject, there was nobody available. So we used to encourage lawyers from Chennai to go there for lectures and take lectures so that we can do something.
But I was in the governing council of the NUJS, National University of Political Science, Kolkata. And we found that we could not get a full professor after any number of advertisements. And therefore, the national law colleges were trying to poach on the professors from other national law colleges. And that we passed a resolution.
Delhi had an effect because Jindal came up there, so all the better one went there. So there, and you have made the profession lucrative at certain levels, so people don't easily come to teaching.
At the most, we could get applications for assistant professor, associate professor, but no application for a professor.
No, but I think some people academically inclined in the legal profession practicing are at some stage willing to go. I know people who are some kind of honorary lecturers there or professors there, in some of your juniors.
The
We are
difficulty is,
facing the same problem in Goa Institute. 2-3 advertisements we made. We are unable to get good teachers.
Difficulty, Mr. Mishra, is like the place. So when they set up at Trichy, nobody took into consideration to the political decision to set it up. Very good infrastructure, everything, but it's a little far away from any of the places where even part-time lecturers are available. So it had to be.
the other problem is requirement of PhD. For a professor, you require a PhD.
Not even with the national law schools, not even for assistant professor, they require the PhD.
Correct. So, but how many PhD in law do we have?
That is the biggest problem. That is the biggest problem.
And how many are doing PhDs in subject connected law? Very few.
Lord, now the things have changed. Now, several applications we for our institution we have got for
Some of
PhD and
the,
research.
we never looked after our teachers for many years. By the time we woke up to that requirement across the board, people had left teaching. And then slowly, with the current situation, there are some youngsters who are committed to graduation but they're younger people who are coming into the profession. Now, middle level is very difficult at higher level.
But the problem really is we could get excellent Indian professors, associate and assistant from abroad, teaching in the US, teaching abroad in England. But the conditions of service are so poor that we are unable to attract them. Otherwise, they would like to come back to India. And one or two who came, I heard, is a science professor who is highly qualified. He was, that is the Bangalore Electronics University. He was told that he can't get a ground floor flat, even though one or two are empty. He has to go to the second or third floor, climbing up the stairs. And therefore, after a year, he resigned and went back. Therefore,
See, the professor,
because there's a pecking order.
Mr. Khanna is almost same vintage as me in the law faculty. There were at least, I think, more than half a dozen professors who used to periodically go abroad and teach for a year or two and come. It was by rotation. Professor Tripathi, Professor Upendra Bakshi, many such Professor Rabai. There were many such people who. So you are updating your education also. They would go teach for 1 or 2 years in the Southeast Asia or the US or UK and then come back. That rotation system also used to work very well because they had opportunity to create some wealth there by reason of what the teaching assignment was. And when they came here, they brought with them some experience.
But the Bangalore NLSIU had a highly sophisticated screen, and the students could, on their laptops, ask questions to the Oklahoma University. And the teaching in Oklahoma University was being broadcast in the NLSIU, in the hall. And therefore, this is one method of taking advantage of lectures which are being given in a foreign university. One thing is the equipment and everything else is
Has to be there.
a little expensive. If your lordship, to answer my lord's question, what your lordship asked was whether in the 24, 1E, he fulfills such other conditions as specified in the rules made by the State Bar Council. Is slightly different from the class and category of persons who will be entitled to be enrolled. This, my lord, could possibly be used against me if, my lord, D is omitted. If this is similar to what is found in 49 and 49A, whether this would not mean that omission of D would mean that he fulfills such other conditions as specified by rules made by so and so, cannot subserve the same activity or power as my lord's D. Perhaps that is what your lordship.
Right.
But then your lordship may kindly see the difference in wording in 49.
The clause AH of 49.
Yes.
AG.
No, AH also,
The Bar Council may make rules for discharging its functions under this Act, and in particular, such rules may prescribe AG, the class or category of persons, and therefore is entitled. It's a different concept. Entitled to be enrolled, and therefore, my lord's, my submission to lordship is this should be attractive. Now, similarly, if your lordship goes,
so therefore, State Bar Council will not have any power.
yes, that Bar Council, State Bar Council will have. Now, if your lordships go to 49 capital A, which is the powers of the central government to make rules. Power of central government to make rules. The central government may by notification of official gazette make rules for carrying out the purpose of this act, including rules with respect to any matter for which the Bar Council or a state Bar Council has power to make rules. The Bar Council of India, according to me, has a power to provide for and pre-enrollment examination, pre-enrollment training. And that power, therefore, is contained in subsection 1 itself. But in addition to that, the C, the class or category of persons entitled to be enrolled as advocates. Therefore, my lord, the same power can be exercised by the central government, either central government or by the Bar Council of India. Now, my lord, if your lordship should look at the judgments which have been given to your lordship's notes, the compilation.
Mishra, you were mentioning, which Venugopal also mentioned, the last order was, is 6 months is required by the special committee to complete this task of verification of certificate of advocate, etc. And 6 months had already been granted. This order, we see, is of vintage, 12th July
Actually,
2021.
the subsequent orders, the court said that no, you first hold the elections, irrespective of this verification of place of practice or the other details, the credentials of the
Election is
candidates.
one thing, but calling for data from lawyers, as Mr. Venugopal said, you see, is something different. This is an ongoing exercise. This exercise should be completed. Actually, you have
For
not
that-
completed the
For
exercise.
that, what we need two directions. One, that we should continue with this. Second is, what is the problem in that matter, Lord, is that when we ask for the verification of some certificate of some lawyer, the universities are asking for a huge amount. In one of the orders, Honorable Mr. Justice Nariman had said that no, on a very nominal amount of rupees 10, the universities or the board should verify and.
So that chapter is also closed.
No, but they are not, the university said, they are saying that it was one time, yeah. Actually, this was one order only for the purpose of election, and that therefore now we are not going to.
How much money are they asking?
200, 300, which is not at all possible for any university.
Sometimes they are asking for 1,000 rupees, bro. That's why we approached the board.
No, they say that it was one time settlement.
But for example, I will say,
We'll examine that, but certainly. if-
Even under RTI Act, 10 rupees is enough. We said that you take 10
Also be a little
rupees.
more reasonable, somebody in the university is to do something.
But to the best of my knowledge, that is over. Because the elections took place in all the state bar councils. And Mr. Manan Kumar Mishra was re-elected as not the chairman of the bar council of India. But that is no more an issue. You don't have to ask for your university certificate now.
No, those were actually sometimes were being asked to verify There are degrees which have been found to have never been issued by the MSc.
That was the purpose, that was the purpose of that.
That was verified for the purpose of allowing them to vote. And 1 million and odd lawyers, they were reduced to 7.5 lakhs.
Yes.
The 7.5 lakhs participated in the elections.
Now question is 7.5 lakh needs to be reduced to what?
No, therefore, that is finished. They had produced the certificates from the universities. And
They're very
therefore,
good because I know in
Right.
Chennai,
Yes.
the Madras High Court, they verified and submitted reports before.
Yes, for online verification, still it is going on.
The,
As far as
some of the
plus two,
certificates were still not found genuine.
yes. Only they are asking, universities alone, they are asking money. Others, not. Even still they are filing, not the certificate of
We'll
proof.
see how to take this up and we, if required, we'll pass some further.
Yes. Only this
But,
Indian case, it's a blocking there. Otherwise, we will verify everything. The members of the bar, they are filing, all the certificate of practice, they are filing it. But we are not able to do it because, only because of this, the judgment which has been blocking us.
but, I was on the three judges judgment. Your Lordship looks at the index of the compilation of judgments.
But both the judgments are authored by the same learned judge.
Yes.
Really?
Even subsequent judgment also.
I didn't notice that. Yes, it's Majmuda. That can't be. Yes.
Yes, yes.
He forgot about his earlier judgment.
Something,
And 3 years had elapsed.
something may have weighed on some issue.
No, he should have referred to it and then distinguished it. But he doesn't refer to it at all.
People make that, so many cases, we will also forget something. It's there.
You see, 1996, volume 3, SCC 342. And this is a case, my lords, where the doctor, who was a practicing doctor, went through the law examination, graduated, was enrolled, and wanted to practice. But he is not allowed, my lords, to practice.
You can give up one license, like see some of the chartered accountants. We have chartered accountant lawyers who have given up their practice as CA.
They have to,
Yeah.
under the Bar Council rules.
So doctor can also, if he gives up his right to practice as a doctor,
He wanted to do both simultaneously.
that would be.
That can't be. Lords, would your lordship come to page 39? Para 16. And if your lordships will come to placitum E, just 3 lines below that.
Fine, you are saying.
Okay, page 39, placitum notes E, between E and F. As noted earlier, the Act, besides highlighting the essential functions of the Bar Council of India, provides for enforcement of the same and sets up disciplinary authorities to chastise and, if necessary, punish members of the profession for misconduct. The punishment may include suspension from practice, removal from the role. 49(1) confers power in the Bar Council of India to make rules inter alia for discharging the functions under the Act. 49(1) AG, when read with section 24, confers the powers in the Bar Council of India to indicate the class or category of persons who may be enrolled as advocates, which power would include the power to refuse enrollment in certain circumstances, the obligation to maintain the dignity and the purity of the profession, and to punish erring members carries with it the power to regulate entry into the profession with a view to ensuring the only profession-oriented and service-oriented people will join the bar and those not so oriented are kept out. The role of an advocate is essentially different from the role of other professions. An advocate is said to belong to a noble profession. The Act itself envisages the state bar councils, who are the elected peers of advocates themselves, to lay down the standards in the professional conduct. That would naturally bring in the way to regulate entry to such a noble profession. And then if your lordship comes down, my lords, to placitum F at page 40. The Bar Council of India is cast with the duty to take all such steps as it considers necessary to filter students in the entry stage to the law course. For example, by providing an entrance test as well as at the stage to the entry point to the profession, by providing an examination or a training course before enrollment as advocate. The Act also deals with the topic of regulation of ethical conduct of advocates from the entry point. Then, minutes, Placitum B
On the next page?
on the next page, minutes.
Yes.
41. Thus, from the pre-entry point to legal profession till the exit point from the legal profession, Bar Council India and the State Bar Council monitor the.
I'm not with you. Where are you?
That shows got it, minutes. Placitum B.
B.
B for Bombay.
Bombay. Okay.
Page 41.
Yes. Yes.
Thus, from the pre-entry point to the legal profession till the exit point from the legal profession, Bar Council in the state bar councils monitor the career of the legal practitioner. The entire scheme of the Act, when considered in the light of the nature of the legal professions to which such entry is given, should be kept in view, considering the submissions of the learned senior counsel that the powers given to state bar to regulate such entries, framing rules, is a piece of excessive delegation of legislative power. Cannot be gainsaid that law is universally described as an honorable profession. An advocate is an officer of the justice under the court, a conduct therefore which is unworthy, and they go on. That are the powers. But earlier, specifically, after referring to AG, they say that it is open to them to have an examination and training before enrollment. And AG Milord is class of category specifically referred to. And therefore, Section 9, that is Placitum after F at page 39. Section 49(1) AG, when read with Section 23, confers wide powers on the Bar Council to indicate the class or category of persons who may be enrolled as advocates, which power would include the power to refuse enrollment in certain circumstances, the obligation to maintain the dignity of the purity of the profession, punish members with its so and so, a view to ensuring that only profession-oriented. The role of an advocate is different. Act itself envisages what the elected peers of advocates. The issue that would naturally bring in its way the power to regulate entry to such noble profession. And the Placitum F at page 40. Thus, the Bar Council of India is tasked with the duty to take all such steps as considered necessary to filter students at the entry stage to the last course. For example, by providing an entrance test as well as at the entry point of profession. For example, by providing an examination or a training course before enrollment as an advocate. Specifically considered, AG is considered to be the source of power. Now, unfortunately, my lords, and I'm surprised that it is Justice Majumdar who has delivered the judgment. And it is Justice Majumdar who has delivered the earlier judgment also. I didn't notice it. Words, the judgment may not. Justice Majumdar's judgment starts at page 182, running page 54.
54.
Running page 54. And we'll actually reduce 50 para 2. These writ petitions under Article 32, as well as the two special petitions moved by the Bar Council of Maharashtra and Goa, Bar Council of India respectively, raise a common question for our consideration, namely, whether the Bar Council of India Training Rules 1995, as amended by the resolution of the Bar Council of India, dated 1998, relating to training of entrants to legal profession, are within the competence of the Bar Council of India, or ultra-virus rule-making powers under the Advocates Act 1961, for short. And in the alternative, these rules are unreasonable and arbitrary and hence violate Article 14 of the Constitution. The writ petitioners who have successfully completed a legal education by getting a requisite law degree, university concerned are contended before us that the right to practice law made available under the relevant provisions of the Act is being arbitrarily denied by the impugned rules framed by the Bar Council of India. Therefore, the fundamental right under 19(1)(g) of the Constitution is violated. Said rules do not impose any reasonable restrictions on the exercise of their fundamental right. Also contended that in any case the rules are so framed as to be totally unworkable, highly unreasonable, discriminatory, and hence they offend Article 14. The civil appeal arising of the SLPA Bar Council, of the Bar Council of Maharashtra, brings in challenge to the decision of Bombay High Court, which upheld the impugned rules and dismissed the petition filed by it, and that is how the State Bar Council is proposed. Now, if your lordship should be pleased to come to para 6. The Grand Council for the petitioner submits that tracing the history and the relevant provisions of the Act and rules, no power of the Bar Council of India to frame the impugned rules. That Section 7 of the Act lays down, but Section 7 is not the section. We are relying upon Section 49 and 49 capital A, and this, my lord, would be a wrong approach, according to me. Section 7, I read Section 7 later. That Section 7 of the Act lays down the statutory function of the Bar Council of India. Provisions thereof do not entitle the Bar Council of India to frame such impugned rules, prescribing preconditions before enrollment of an applicant as an advocate under the Act by requiring him to undergo pre-enrollment training and apprenticeship as laid down under the impugned rules. It was also submitted that Section 24, subsection 3D of the Act also was not available to the Bar Council of India to frame such rules. As a sequel, it was submitted that the rulemaking power of the Bar Council of India as laid down by Section 49 would not be present to service by it to support the impugned rules. On the other hand, Learned Counsel in writ petition submitted that even assuming the impugned rules fall within the rulemaking power of the Bar Council, the rules named are so obnoxious, arbitrary, unreasonable, and I don't see it as looking at it from a student's point of view, and unworkable, that they violate the fundamental right of the petitioners under Article 14 of India in any case. The appeal arising from SLP, filed by the Bar Council, raising the question of retrospective effect of the rules in question projected an additional contention which may not survive if the rules are held to be ultra-virus. Rulemaking power of the Bar Council in support of the contention raised on behalf of the petitioners by the Learned Counsel. Reliance was placed on a three-judge bench judgment of this court in Indian Council of Legal Aid and Advice. Now, in this case, a limit of 45 age was not imposed by the Bar Council. You can't enroll after the age of 45. That means retired persons cannot come and enroll, which I don't think was correct. While Sri Rao, learned senior counsel of the Bar Council of India, submitted on the other hand that the said decision by interpreting the provisions of 49(1)(a)(h), not AG, was rendered per incuriam, as it had not noticed the decision of the Constitutional Bench of the Court, Lily Thomas, as well as the express provisions of section 24(3)d. Mr. Rao submitted that the impugned rules were legal and valid and were properly framed under section 7, read with section 24(3)d and section 49(1) and 2 of the Act. In the light of the aforesaid rival contentions, the following points arise for our consideration. Whether the impugned rules are ultra vires rulemaking power, Bar Council of India is available to it under the provisions of the Act. If the aforesaid question is answered in the negative and in favor of the Bar Council of India, whether the impugned rules are arbitrary and unreasonable and so as to violate the guarantee of Article 14. Of course, this is not arise. The impugned rules are legal and valid, whereas one in the Bar Council of India appeal, who has got his law degree prior to the coming into force of these rules, can be required to comply. That both these questions did not arise. And now, if you allow, it needs to go to para 16. Which is at page 70. Para 16. It becomes at once clear that the impugned rules are said to have been framed by the Bar Council of India in exercise of the statutory powers under section 24(3)d. We have already traced the history of the aforesaid statute provisions. No doubt true that subsection 3 of 24 starts with a non-obstante clause, provides for notwithstanding anything contained in subsection 1. A person mentioned in categories A, AA, C, and D may be admitted as an advocate on a state roll if he applies as laid down in clause 1 and fulfills the conditions specified in clauses A, B, E, and F of subsection 1. Objects, reasons for enacting said provision, as noted earlier, have clearly laid down that it was felt by the legislature that despite the operation of section 17 and 24, there were some persons who, though not covered by the said provision and had not satisfied the conditions of enrollment as laid down in these provisions, deserve to be enrolled as advocates. With the end in view, the Bar Council of India was provided with a rulemaking power under subsection 3D of section 24, so and so, indicating and such otherwise ineligible candidates for enrollment and even for such class of persons to be enrolled. Now, my lord, according to me, there is no discussion of section 49. And if your lordship should be pleased to go to para 16, my lord, end at page 72. Or the fourth line. It is necessary to note that this power is available to the Bar Council of India from 1964, all throughout till date. While between 1963 and January 74, pre-enrollment training and examination could be prescribed as a condition of the State Bar Council, as per the then existing condition T of subsection 1 of section 24 for such enrollment. Consequently, it cannot be said that the rulemaking power under section 3D or section 24 still enables the Bar Council after deletion of section 24(1)d to promulgate such a rule, by which almost by the back door an additional condition of enrollment to restrict the entry or otherwise of eligible candidates for enrollment under section 24(1) can be imposed. Consequently, section 24 subsection 3D cannot legitimately be invoked for sustaining the impugned rules. Para 17. We may also mention one additional submission of senior advocate C.P. Rao in support of the impugned rules. It contains a section 24(1) of the Act that enables the rulemaking authorities to enact rules which may go beyond the statutory provisions of 24(1) as enacted by the legislature and therefore the Bar Council of India as a unique authority can be exercise of such power add to the conditions of enrollment as expressly laid down in section 24. It's not possible to agree with the submission with simple reason that section 24 itself contemplates the qualifications of persons whose admission as an advocate of so and so. To reiterate, granting admission to a person for being enrolled as an advocate under the Act is a statutory function of the State Bar Council. The Bar Council of India has no role to play on this aspect, exactly the opposite of what not the same judge had held, sitting in 3 judges' bench. The Bar Council has no role to play. All it has to do is to approve the rules framed by the State Bar Council under 24(1), laying down qualifications for a person to be enrolled on the state role as an advocate. We have therefore to read the rulemaking power mentioned in 24(1) conjointly, conjointly with the rulemaking power State Bar Council as provided. Now, this is where the learned judge had forgotten that 3 years earlier he had said it exactly the opposite. And now, if your lordship would be pleased to go to para 21. Page 74. But even that apart, let us see whether any of these provisions can sustain the imperial rules, even on the assumption that such an exercise otherwise remains permissible one for the Bar Council of India. Section 49(1) AF. We are not with AF, we are dealing with AG. Deals with the minimum qualifications required for admission to a course of degree. I recognize. That obviously has nothing to do with the imperial rules. Oh, then comes clause AG, which deals with the class or category entitled to enroll as an advocate. To recapitulate, section 49 is already on the statute section 64 till January 67. January 67. Section 49 may, and when the topic of pre-enrollment training and examination was solely within the domain of State Bar Council, and once on the said topic, the State Bar Council has framed the requisite rules. They were then the subject to approval of the Bar Council. Therefore, there is a complete code in this connection. Once the State Bar Council framed such rules and got them approved by the Bar Council of India, then because of the trust of the parallel provision of 24(1)D, which is operative at that time, it became a precondition for enrollment. There cannot be two parallel preconditions of enrollment which can be simultaneously imposed. One under 24(1)D, the State Bar Council concerned, exercise under 28(2)B, which existed on the statute book in 64 and 74, and also the possible provisions for imposing such preconditions for enrollment by the Bar Council of India, taking resort to the supposed wide wordings of section 49(1)H during the very same period as during the period section 24(1)G, so and so. If such a concurrent power is envisaged by section 49(1)H, then the Bar Council of India, instead of being an approving authority at the relevant time, would itself become a prescribing authority. The rules, my lords, are to prescribe, and special power has been conferred in connection with pre-enrollment. Also, to be before us in the scheme of the Act, enrollment of advocates are considered not allowed. It must therefore be held that the rulemaking power contemplated in the 49(1) for being exercised by the Bar Council was pertaining to only those persons who are thought to be enrolled as advocates, though they may not be eligible to be enrolled. 6 students. In other words, enabling rulemaking power only by which the Bar Council will add to the category of eligible persons for enrollment, which would have otherwise remained outside the sweep of the statutory provisions scheme of eligibility for enrollment as laid by section 24(1), did not contemplate any power to curtail the existing eligibility of the applicant under 24(1) for enrollment as advocates. It's only for such additional class or category of persons that the enabling provision as per the set rules making power be available to the Bar Council of India, to the Bar Council. It is difficult to appreciate how by the process of interpretation an enabling provision can be treated as a restrictive one. In fact, on a conjoined reading of 24(3)D, 49(1)(a)(g), the conclusion becomes inevitable that the Bar Council of India, in excess of the statutory provisions entrusted to it under Section 3D of Section 24, can frame a suitable rule for bringing the aforesaid enrollment provisions, otherwise would have remained out. The rulemaking power under Section 49(1)(a)(g) is to take color from the statutory function entrusted to the Bar Council of India by Section 24(3)D. As we already held that 24(3)D does not enable the Bar Council to impose additional restrictions on the eligibility of an applicant who seeks enrollment as per 24(1), it by necessary implication, power may under 49(1)(a)(g) also cannot enable such an impermissible excess. The rulemaking power under Section 49(1)(a)(g) is ancillary to the statutory function entrusted to the Bar Council of India by 24(3)D and cannot travel beyond this. Then para 24. So far as this Section 49(1)(a)(g) is concerned, is also to be kept in mind, as noted earlier, that 24(3)D and Section 49(1)(a)(g) were simultaneously introduced in the Act in 1964. At that time, there is specific provisions regarding pre-enrollment training under Section 24(1)D and 24(2)D. This enactment of Section 24(3)D and Section 49(1)(a)(g) could never have been intended to include implied power function to make pre-enrollment training rules. And that too with the Bar Council of India, it had nothing to do at the initial stage of enrollment of advocates. In this connection, it's also used to refer to 49(1)(a)(g) with Section 29. And 29 says, subject to person and any rules to be amended. As from the point of view, only one class of persons. I don't see a show that. But therefore, this is the entire approach of unit judges. And therefore, in those circumstances, one would be surprised when one finds that the three judges bench has not been recognized. Would your lordship like to go back to the three judges to find out what exactly they have said in regard to 49(1)(a)(g)? If this directly covered it, para 16, at page 14. Please see me on page 39. If you don't mind. 9.
You are referring to Section 49(1) onward.
49.
Let's come back.
Section 49(1) confers power in the Bar Council to make rules, inter alia, discharging its functions under the Act. Section 49(1)(a)(g), when read with Section 24, confers wide powers on the Bar Council of India to indicate the class or category of persons who may be enrolled as advocates, which power would include the power to refuse enrollment in certain obligation to maintain the dignity and the purity of profession and to punish serving members, carries with the power to regulate entry into the profession with a view to ensuring that only the profession-oriented and service-oriented people for the bar and those not so oriented are kept out. The role of an advocate is essentially different from the role of other professions. The advocate is said to belong to a noble profession. Act itself, when we said the State Bar Council, who are the elected peers of the advocates, themselves to lay down the standards for the professional conduct and etiquette, that would naturally bring in the way the power to regulate entry to such a noble profession. It is said that law is a jealous mistress, and that calls for undivided loyalty and unflinching right, drudgery, etc. And then if the lordships will come at the bottom of that paragraph, that is not President, this even at the re-entry stage of an advocate to the profession. His equipment as a student of law and the requirement of basic legal education, with which he should be armed before he can aspire to be enrolled as an advocate, are also looked after by the Bar Council of India and the State Bar Council, which works under the general supervision and control of the apex body, namely the Bar Council of India. Thus, the Bar Council of India is cast with the duty to take all such steps as it considers necessary to filter students at the entry stage of law course. For example, by providing an entrance test as well as an entry point to the profession, by providing an examination or a training course before enrollment as an advocate. The Act also deals with the topic to regulate a profession and control of advocates from the entry. Therefore, my lords, the three judges have expressly referred to 49(1) AG and then come to the conclusion that the Bar Council of India is to lay down the examination as well as the training. Therefore, in those circumstances, the respective submission will also says that a very elaborate judgment in Milord's the
So one part, if I read correctly, of the last paragraph talks about the issue of duty passed by examination, etc., before the enrollment of the examination. Correct?
yes,
So this is prior to enrollment process. And then the last sentence also deals with the topic of the regulation of professional conduct of advocates from entry point itself. So are you are intending to read in the next sentence
yes,
that this is also part of the regulatory mechanism?
that's right. Question is
The
specifically
thing is that this last sentence deals with the topic of regulation of professional conduct of advocates from entry.
so
So
by
Venugopal,
providing entrance
just-
test,
just one more thing. In this case, that is Dr. Chubani's case, the issue was whether you can practice both as a doctor, medical profession, and therefore that was a controversy whether, and in that context, 49 AG is being interpreted. The issue with whether the examination, pre-enrollment examination or training was not the direct subject matter.
maybe.
Now, number two, there are two aspects of the issue. One is training before enrollment, and the second is pre-enrollment examination. As far as pre-enrollment examination is concerned, yes, you are right. It can be said that both the stipulations were there in the earlier clause D to section 24. Those have been omitted. Those have been omitted. There is no doubt about it. Those have been omitted, and they have been omitted for a particular reason by the legislature. So when we look at the issue before us, we do have now post-enrollment examination, which has its own problems and faults which are being addressed. But training as such is now internship, etc., which is not really.
That's a different issue altogether. I'll deal with that separately. Lords, please go to the beginning of para 16. Para 15, Lords. It is in this background of the aforesaid statutory provisions and the relevant rules that we now proceed to deal with the points for determination that have fallen for consideration. Para 16, point number 1. So far, in the question of excessive delegation of legislative power is concerned, we must note at the outset that the Act has been enacted as seen earlier with a view to regulate the right of advocates to practice law. The rules framed by the Bar Council of India, especially relating to the standards of conduct, clearly aim at securing high standards of competence in legal services and seek to strengthen professional relations and promote the welfare of the society as a whole. Specific norms have been laid down in respect to the conduct practicing in the profession vis-a-vis the court decline. The opposite law and program. Law is duty to train juniors and impart free legal aid. The poor is part of the ethics. The code provides standards for identification and measurement of professional deviance. As noted earlier, that highlighting the essential functions the Bar Council of India provides for enforcement of the same and sets up disciplinary authorities to chastise necessary punish members of the profession. Punishment may include suspension from practice as well as removal in the role of advocate. Section 49 one confers power to make rules inter alia for discharging functions under Section 49 one AG when read with 24 wide powers in the Constitution. Pausing here, Lords, it is not that
far as the provision of bar council exam is concerned, strengthening of that measure is concerned, bar council playing a role in seeking that, in helping getting placements, all that is fine. There is no discussion. There's only one aspect which troubles us, that if we have a prescription where bar council prescribe, yet you must, apart from all this, compulsory have a tutelage with somebody or a training with somebody. How will it work out? The people who come from a different scenario, a village scenario, where will they get the seniors? And I'm sure you are quite aware, there were situations which arose where, in order to permit the juniors to get a certificate that they were, consideration is to pass reverse way. This is an aspect which is still troubling.
No, I'll deal with it first. I may finally say, my lords, your lordships are sitting in a constitutional bench. Therefore, what neither of these two judgments would control your lordships. And this
So
is,
that's true. The only thing is, we read it in a manner.
therefore, I will deal with it independently as to whether that power exists or not, and whether your lordship should hold.
Whether we need to, what is your perspective of that power? And whether we should exercise that power to create a scenario where
Very
you
good.
must go through a training as prescribed by the bar council.
Apart from that, they'll have to answer, if they want training, will they make a provision also for payment of some stipend?
Yes. No, I told your lordship.
Because even in the Chartered Accounts Act, there is a stipend now prescribed under the rules.
Yeah.
So that's, they'll have to take that call.
But I told your lordship that the Jammu and Kashmir young lawyers had written to me, saying that they were not being paid a single pie. Well, after graduation, they would be asked to work. Therefore, perhaps a committee of the.
See, whether they look into it, as my brother put it, they will have to make financial provisions. We are talking today of, on verification of lawyers, this thing, they feel that, applying a test of 100 rupees for this thing also is problematic because a lot of fund flow occurs. Now, if they have to ensure, let us say 500 rupees, start with the basic. Suppose 500 stipend has to be given. Who will give the stipends? Junior, senior will not keep the junior. In reverse, let me say, I'm aware of the fact where at the relevant time, people were paying the senior to get a certificate. See, we are all kinds of people in this hierarchy which exists. Where will they face that burden from? And if the bar council has to face the burden, if 75,000 lawyers join in a year, 75,000 into some, at least say 16,000 rupees a year,
They may not be able to.
they will have the wherewithals to do it.
They don't have.
That's what I'm saying. So something may look nice, but it may work both problems. So just thinking aloud,
Yes.
if we water down to some extent, make sure there are no impediments in bar council working. Work out that scenario which we've done in the other matter of there being one register for first, second register when they clear it. The very fact that there is a hiatus period in their taking the examination, then registering themselves for purposes of examination, then taking the examination, they would be some way or the other would work out in between. And the bar council can carry out the larger role of trying to persuade lawyers to find placements as much as possible. That can be, I'm just thinking aloud. It can be a workable via media process.
Just as Bar Council is sending up the letters to the various lawyers
Yeah.
to find out the conditions in which they are functioning.
Right.
They can send lawyers to all those who have put in more than 25 years practice. They can send letters to them asking, do you have juniors, how many juniors, and provide for it by
That proposal we have given.
That proposal is already there. That how to
And whether we
encourage
are-
seniors to accept people nominated by the bar council. But bar council may not be able to meet, as it said, the financial liability
That-
of paying the stipend. If it can't take that, then this problem will persist, even if in a constitutional interpretation we do that, where people who will get a placement through the Bar Council, or if you provide a provision, our greatest fear is it should not become another strain on that young advocate who may come from difficult economic, social scenario, that he is actually going out of pocket to get this 1 year of training. As you said, there are people who don't pay, you are saying, at all. But if it will become compulsory, they will say, now you are working with us, and so you pay us something. It happened, and I'm aware that such things happen.
No senior can possibly ask for services
That will be a rare
from a
aspect.
lawyer or from anybody else
You, Mr.
without
Venugopal,
making a payment.
Mr. Venugopal,
No,
there are lawyers,
therefore,
there are
the
lawyers.
question is whether the Bar Council of India can possibly send out letters and ask,
Yes, certainly.
are you having
They can
juniors,
ask,
how
are
much
you
are you
ask you
paying?
how many juniors you have? One.
And how much
Are you
are
willing
paying?
to accept juniors nominated by the bar? Why 25? I said somebody who is even today, the more affluent lawyers in 10 years' time are making enough money to keep juniors. So suppose each of them accommodates one person nominated by the bar council from a different. So that can be a workable solution. I would say even if they send letters to people who have 10 years plus of practice, that much is required. Do you have juniors? Are you willing to keep somebody nominated by the bar council? I think it will be a very salutary exercise for giving an opportunity to the younger lawyers.
It's in the internship. We are paying the interns. We have 3 interns every month.
So therefore, I'm saying,
We are paying about 15,000 rupees.
so
each.
the
For that one
encouragement
month.
is like this, that the encouragement more is towards persuading them to bear this financial burden and accept the responsibility of taking people.
May I only say something? Your lordships are now examining the power under that. Thereafter, if your lordship found the power, they will have to form a subordinate legislation in which, as far as training is concerned, Bar Council has to take the responsibility through the state bar councils of assigning the incumbent. Otherwise, it will not be achievable at all. Power is one thing, how they exercise it in this case, the 1995 training rules were struck down as ultra virus. All that your lordship are now examining is power and also mentioning as to how, when they exercise it, exam is no problem. They will have to make sure, that
That whatever part exam is not a problem.
yes, training part will not there.
Even on power,
Yes.
so far as providing a training period is concerned,
You have
you
to-
will have to address us on.
Yes, power will,
Some of the
power
issues
will
there is-
address your lordship, but even if power is there.
We still have some thoughts which need to be
Yes.
satisfied.
But the
As to
manner of
existence of
exercise of it will have to be.
That's a separate. Existence and exercise are two
Power
different.
exercise, but that assignment of the.
We only said, if we stretch ourselves,
Yeah.
suppose we are not fully satisfied, the power exists, and we stretch ourselves in construing it as a power exists, the implementation itself will become a problem.
Tomorrow, even if Parliament amends and makes specific, I find the power in several sections. Still, this question will arise. So, in this
If
subordinate.
the parliament this way, it should logically be giving funds then. Otherwise, how will it work? If the government says we allocate X amount of funds to the bar council to be given as stipend for to the people nominated by you, they will have a fund source. Problem is a fund source.
Then the enabling power will be there. Bar council, if it is not able to do that, will not recommend training. But it should have the power to do that. And when it is vested with funds too, will not also assign.
Perhaps we are just overlooking one thing. Even the juniors who are working find it difficult to meet
Yes, yes.
parents.
That is.
And number two, as far as the interns is concerned, they cannot even assist them in appearing in the court to take over passovers or take adjournments or argue small applications. They're not given that authority. So to them, it's just the office work for which you are employing them, or you will be giving them training.
For giving them briefs to study.
Yes, that's will be the only.
What happens?
How many, do we have enough infrastructure in the sense that lawyers who are practicing in courts will be willing to do that? To take over 75,000 every year?
reading that.
That is how my lord has suggested that you incentivize it for their
Right,
own,
but if we-
seniors' own growth in the
If we,
profession.
Mr. Prathan, if we read compulsorily, that training has to take place.
Compulsory won't work.
That's what I'm saying.
But
only.
incentivization will work.
Yes.
But
Your
compulsory
lordship
will
tell the
not.
lawyers in Delhi.
That's
or-
a separate matter. That's
that your designation will depend on this. Active lawyers will take juniors and pay the stipend. Elevation will depend, but don't make it compulsory.
Rather, on the lighter side, the, the designation issue has become more complex than even elevation.
Much better.
Okay, thank you.
Right. Was asked for me. I don't think para 16 of the 1996 judgment is obited. For this reason, if your lordship should kindly see para 15, which is at page 39 of the compilation.
Yes.
It is in the background of the aforesaid statutory provisions and the relevant rules. Proceed to deal with the points of determination that are followed.
Yes.
Therefore, the court believes that this will be one of the points.
Correct.
Point number one, so far as the question of excessive delegation, we must note at the outset that the act is enacted, as seen earlier, with a view to regulate the right of advocates to practice law. Then they go on. Therefore, my lords, according to the bench of 3 judges, this is a relevant issue which they have to decide. And therefore, my lords, with great respect, I would say that your lordship should not say that it is arbitrary. The judges thought that it was necessary for the decision of the case. I mean, that would be the submission. Now, my lordship, your lordship should be pleased to, and therefore, my lord, going back to 49,
Yes.
Section 49, my lords. My submission to your lordship should be, Bar Council of India may make rules for discharging its functions under this Act, and in particular such rules may prescribe. The generality of this power would include, my lord, or comprehend anything which is necessary to bring into the bar fully qualified lawyers. And if there is a high disparity between law schools, and you want to ensure that it is only those who pass out of the law school, which is up to the standards which the Bar Council of India has prescribed, would be entitled to practice law. Because otherwise, my lords, they will be sacrificing the interests of the clients. Then in such a case, this wide power which is there in discharging the functions under this Act would include that it will be a fully competent lawyer that should emerge for the right to practice. And thereafter, my lords, it specifically says, so far as the AG is concerned, the class or category of persons entitled to be enrolled as advocates, and therefore class or category of persons who are entitled. Category of persons are those who would pass the Bar Council exam. And therefore I will submit, my lord, that this power exists, both, my lord, in the Bar Council of India as well as the Bar Council of the central government.
Is there, I just want to know, see, on the issue of the exam, is there anybody who is having a contra view, who is canvassing a contra view?
Because there are few people who have filed writ petition before your lordships, wherein they have challenged it. And most probably a few of them are here who have said that there should not be any examination at all.
Well, I just wanted to know for a
I
record.
have a petition, my lord, transferred case 13 of 2011.
Yes.
Anuj Agarwal,
Yeah.
who has challenged, my lords,
There are a lot
Bar
of such
Council
writ.
examination.
Okay.
Therefore, there is a challenge, your lordship would
You
hear.
are saying there should be no bar exam.
Lord,
Lordship, during the course of the arguments, I'll convey under which, how is it completely arbitrary and unconstitutional without an amendment to the Advocates Act? And that, your lordship, I'll show through the.
What is the constitutional? First, what is the constitutional provision it violates?
Your lordship, under the Advocates Act, it has been specifically prescribed. There are certain sections which are specifically given for disqualification. There are specifics, your lordship. I'm not talking about just V. Sudhir, your lordship. There are certain things during the course of the arguments, if I, your lordship, will
Okay.
get to submit, I'll be much obliged.
Okay.
Grateful.
Lords, I believe your lordships have the Bar Council of India rules.
Yes, we have given.
Yeah. Yes.
And at page 1,
Rules of
these are rules on standards of legal education and recognition of degrees in law for the purpose of enrollment as advocate,
Yes.
inspection of universities for recognizing a degree in law under 7-1H, 24-1C2, 49-1A, AG, and D of the Advocates Act made by the Bar Council of India in consultation with the United States State Bar Council. Therefore, this is also comprehensive AG. And if your lordship should be pleased to go to the third schedule,
Yes.
well, it will be page number 32. At 34,
Yes.
where rule 25, minimum period of internship. Each registered student shall have completed minimum of 12 weeks internship for 3-year course stream and 20 weeks in case of 5-year course stream during the entire period of legal studies under NGO, trial and appellate advocates, judiciary, legal regulatory authorities, legislatures and parliament, other legal functionaries, market institutions, law firms, and companies, local self-government, and other such bodies as the university shall stipulate, where law is practiced either in action or in dispute resolution or in management, provided that internship in any year cannot be for a continuous period of more than 4 weeks, and all students shall at least be gone through once in the entire academic period for trial and appellate advocates. Each student shall keep internship diary in such form as to be stipulated by the university concerned, and the same shall be evaluated by the guide in internship and also a core faculty of the staff each time. The total mark shall be assessed in the final semester in the so and so, under the rules in Schedule 2. Therefore, my lord, so far as these are concerned, there is an elaborate provision for internship. And this is a wide, my lord,
This is, Mr. Manopal, this is an internship during the carrying out of the course.
yes, my lord. Now, the difference is
How
this.
much it is followed for a 3 years course in different law schools would be
Parking also, 30 marks for internship.
Parking is there, 15%, 15 marks are there.
Are you able to check whether I agree?
No, they are coming, all the students are coming to the court and they are along with the seniors and they are, yes, they are, what are the cases they have listened?
Across the law schools that happening, right?
Yes, it is happening in the law school.
More prominent law schools, I'm not.
Yes.
It would happen. I'm only concerned that across the country, how many law schools now recognize?
Yes, that is true. Correct. The 1700 million, 1700
My lord,
throughout the country.
And different in states differently.
Yes, different states.
No, in different states, numbers will vastly vary.
Colleges was
How many are in Tamil Nadu?
But Tamil Nadu only very little. Tamil Nadu 15 or 20 maximum.
How much in Andhra Pradesh?
Andhra Pradesh nearly for 60 million, 60 colleges.
What I'm saying.
Yes.
How many in UP?
UP is the problem, my lord, several times. And we have marked, my lord, UP within a period of 2-3
And
months.
your home state, Mr. Mishra?
My home state is the poorest one, only 11 colleges.
Only government college. Only government, almost.
Including government colleges only.
Some places there's just one too many. In some places may so there's something you have to see the redistribution is where more colleges can be opened, where less colleges should be there. As long as the performance is good, there is no problem.
No problem. What Lordship rightly pointed out, the Attorney General was respected. But he has said earlier, 15 years back, entirely different. Now the entire scenario has been changed. Some private colleges seems to be very extremely good. They are conducting and the training is giving separately and we are not coming to the court regularly. Because of the due to pandemic, they are avoided. Otherwise, they used to come everywhere. Because of even the Madras High Court, completely fully crowded area because of the students are in all courts.
The problems are with the state-owned universities or the institutions. They never appoint the teachers, even after several warnings, the government colleges, the constituent colleges, there is acute dearth of teachers. For last 20 years, in very dream college of Patna University.
Where are you going to get the team? You suppose you advertise. Are you able to get an advertisement? I found half the time you cannot get qualified teachers at the relevant stage.
So far we have given.
I was party to it, therefore I'm saying in Trichy, it was so difficult, for example, to get somebody to teach partnership. There was nobody to teach partnership and contract. There were problems.
200 to 300 shokas notice we have been issued by many number of state governments. We have issued temporary. They will say, Lord, I will come and do it immediately within 6 months, 3 months. They are taking time and go. Lord, we are checking it every time. Whenever we receive the complaints, we are going on, we are checking it.
But what is right? Getting a good teacher is a big problem.
Unleash not properly qualified lawyers. Maybe the repercussion is not so much as unleash doctors, but still, ultimately, they represent people who have faith in the system to come. It's important that some at least basic level of quality must be maintained. Therefore, we'll hear the other side as to what to say, why exams should not be done.
Yes.
Yes, Mr.
you should take this book.
Yes.
That is the Bar Council of India rules,
Yes.
page 25. Since I got item 24,
Yes,
moot court exercise and internship.
yes.
The paper may have three components of 30 marks each and a viva of 10 marks. Moot court 30 marks. Observance of trial in two cases, one civil, one criminal, 30 marks. Students may be required to attend two trials in the course of the last 2 or 3 years of LLB studies. They'll maintain a record and enter the various steps observed during the attendance on different days in the court assignment. This scheme will carry 30 marks. Interviewing techniques and pre-trial preparations and internship diary, 30 marks. Each student will observe 2 interviewing sessions of clients at the lawyer's office, legal aid office, and record the proceedings in a diary. They carry 15 marks. Each student will further observe the preparation of documents and court papers by the advocate and the procedure for the filing of the suit. This will be recorded in the diary, which is the fourth component of this paper, the YOC examination, so and so, so and so, part one. Therefore, my lords, an elaborate, which I think Mr. Vishwanathan showed me this particular para, and an elaborate procedure, my lord, is laid down. My submission to your lordships is this: if this internship, which I think with the exposure to the courts, where unfortunately, my lord, because of the huge crowds which your lordships would be having in the Supreme Court, the interns are not allowed. But if your lordship permits 10 or 15 or 20 per day, and the same persons won't be, and the register is maintained, and you select only those so that they have 1 day's experience of coming to the court and watching the proceedings in the court, I think it will be emulating. I mean, it will be very good. And therefore, my lords, I don't think that the apprenticeship in a lawyer's office will necessarily be superior to, my lord, the requirement of the internship.
I wouldn't say superior, inferior, Mr. Venugopal, but for a litigating lawyer, proposes to go into litigation, to get a feel of the court.
By attending the courts. And they are attending in subordinate
In fact,
courts.
I must confess, we are beneficiaries of law clerks.
Yes.
Some of them who have given up their assignments with established law firms and come to, so they must have found something worth the while to come to
Right.
work on this
On
subject.
their biodata, my lord, it will be a very valuable one. And so far as the US is concerned, there are local military Supreme Court judge. You are assured, my lord, of a professorship or you'll be taken into the best of law firms automatically. Therefore, my lords, is it necessary then to have internship, to have training under senior lawyers, to have, or even under NGOs and other bodies, and litigate? What litigation? To help the senior lawyer in drafting it. And I do use my interns for a lot of research, and they're brilliant. And they are going to Westlaw, they're going to LexisNexis, and download a lot of very useful material. Therefore, my lords, according to me, I don't think that insistence upon having a training under apprenticeship under a lawyer for a period of a year is necessary if this is a substitute. Lords may consider that.
Okay.
But so far as, my lords, the exam is concerned, I think it is essential. And if your lordship takes the volume 1, volume 2, my lord, of it, my Mr. Siddhant Kohli has in his enthusiasm prepared a lot of relevant material which I don't think the lordship will find the time to go through. The lordship would be pleased to see
7:39.
there is an all India bar examination. This is 7:39. Now, your lordship saw that at the beginning of the rules, it had said under the various provisions of 49. Now, here, my lords, your lordship will see the second paragraph. In view of the above,
Will you say it, Mr. Venugopal? I'm sorry.
7:39
7:30.
of volume 2, my lord, of the heavy.
Rimpal, we will ultimately need your expertise, how to put it in a short note and give it to us. Some short note will have to come from you of what, crystallizing what the direction of your synopsis. We've noted it, but one note, 3-page note.
Very good. I will do it. Now, all that I was trying to point out was
Yes.
that there is already the exercise of power for holding an examination.
Yes.
This is post enrollment. In view of the above resolution, the following rules are framed. Insert a Rule 9 to 11, Part 6 of the Bar Council of India rules, conditions of right to practice, and the section 49(1)(a)(h) of the Advocates Act.
Yes.
And since 49(1)(a)(h) deals with advocates, as necessarily, my lords, if 49(1)(a)(g) also would be available, because the wording is similar, and we are now using, and this has stood the test of time. And therefore, my lord, because this says these are All India Bar Examination rules of 2010. Therefore, now 12 years have elapsed. Then no advocate enrolled under 24 shall be entitled to practice under Chapter 4 unless such advocate successfully passes the All India Bar Examination. And therefore, in my respectful submission, that instead of the post enrollment, because my lord, so far as he is concerned, he practices during this period. And then finally at the exam he fails. And then he'll have to stop practice and he'll be humiliated and he has to go home. And
That's why for this interregnum period,
yeah,
after intimation and then the system which Mr. Vishwanathan helped the Bar Council in creating, you have a register where everybody is passed and wants to take the exam is enrolled. Those people are not permitted to appear, but they go along with the councils, go to court and get an exposure. So in a way, that itself is an equivalent to some kind of a training.
training. Yes, that's what I was trying to tell you.
And then ultimately they have to take the exam.
Now, this my lord is
Mr. Venugopal, can you just read Rule 9 once again? Rule 9 at page 739.
no advocate enrolled under section 24 shall be entitled to practice under Chapter 4 of the Advocates Act unless such advocate successfully passes All India Bar Examination conducted by Bar Council of India. It is clarified that the bar examination will be mandatory.
But that's very insane. You can only go to court. So that's just correct. They don't appear before the courts, but they accompany the lawyers, go to court and,
No, they appear. They appear.
appear.
They
They
appear.
appeal.
No, but if you look at Rule 9 carefully,
Yes, my lord.
just read that.
The prohibition.
That says, shall be entitled to practice under Chapter 4 of the
Yeah.
Advocates Act 1961
Yes, my lord.
unless such advocate successfully passes the All India Bar exam.
Look,
They take a undertaking, provisionally they are enrolled.
yes.
We are the interpretation of the rule. We are not going by the actual practice.
I think what you do is, that means you say that you will undertaking that you will clear the bar exam in 2 years.
2 years, provisional.
That is why this whole issue came that there were people who had not cleared even the exam and continues. Which is the consequence, Mr. Venugopal, you are right, will arise. So suppose somebody practices for 2 years, doesn't clear the exam. That is the system we try to build, so you can detect if somebody is not clear and stop his practice and be clear.
But your lordship shall be entitled to certificate of practice. Pre-enrollment, there can be an exam. All of those issues get taken care of. The employed people can try. Then after that, they enroll. Then the only question is, well, once they enroll, they will have to give. That was a scenario where enrollment was not mandatory to write the exam. Your lordship worked out that A register, B register. Now, if the exam is to be held pre-enrollment, none of these issues will not be arise, provided your lordship find the power in the act which we will canvass.
Just
Limited to,
sorry.
limited to exam.
Limited
Not
to
talking
exam.
this thing.
Of course, the other issue your lordship raised about training will have to be addressed in the context of making a provision for the lawyer who would train. That part will be addressed, your lordship. Exam will not, there is power in the act, notwithstanding.
Rule 9 contemplates post-enrollment
Post-enrollment.
and there is
No.
complete ban.
No, my brother in fact just pointed out, Look at page 740, clause H.
Upon successfully passing the bar exam, shall be entitled to certificate of practice.
Actually,
Then he cannot practice as per
the
the.
attorney, so far
Yes.
at present, practices aside,
Yes.
can a lawyer really practice? He may enroll, but he can't practice unless he clears the examination. He may do some, but what the bar council is saying, they are apparently appearing, doing everything.
No, but,
They don't say.
Yes,
but no advocate enrolled under section 24. Therefore, he is enrolled as an advocate. And thereafter, he can't practice. And until,
Right to practice comes under chapter 4 of the Advocates Act.
Section
Yeah.
29.
Not before.
section 30.
So, section, and this is what your rule 9 also says.
yes,
No advocate enrolled under section 24 of the advocate shall be entitled to practice under chapter 4.
yes.
So chapter 4 will come into play after he has passed the all in AIB.
Yes.
And therefore, it's, right to practice is interdicted until he passes it.
Yes, exactly.
Therefore, to permit him to practice is not something contemplated there.
Under
Until he
this-
passes.
What I think has been happening
Provisional.
is they don't permit them to file wakalats or do anything or interfere.
We are not
But
permitting.
they are really acting as proxy counsel. Is
Yes.
this correct?
Yes, might be.
They're also not
But
regular,
there-
regular practice.
May I clarify, Manoj? May
How
I
can you
clarify?
be regular practice? Unless you file a wakalat, how can you
No,
be regular
because
practice?
they are appearing, Millards, what happens, we give them a provisional certificate, the state bar councils.
Another
They file
provision.
wakalat.
So,
My
No, no,
specific-
another
Can
provision.
they file wakalat or can they not file
No,
wakalat?
no, 2 years they can file wakalat, but after the enrollment,
No, whether
they are
that can be done
running
in
time.
the
Time
teeth of Rule 9, can
Yes.
you do that? Can you allow anybody to practice under section 29 and 30 in the teeth of Rule 9?
They are not filing wakalat, almost they are not.
Filing, even they can't appear also before the.
Yes, correct, correct.
Can't appear before.
Yeah,
the court.
yes, we can't appeal. That is correct. That's correct.
No, that's what I'm saying. As the rule reads, neither, therefore we went step by step. Can they file wakalat? You initially said.
No, they are not filing wakalat. They are not
They
filing.
can't file
wakalat.
wakalat.
Yes, they are not filing. They have to succeed
Then,
for not the all their bar
therefore,
exam.
They cannot file wakalat.
My friend here has been filing a wakalat before passing the exam.
Therefore, there is no consistent, this is a problem. See, what is happening is, it is not treated as a pre-qualification to practice, but is treated as the moment you enter your name in the bar, you can practice. With a qualification that if you must clear the exam in 2 months. So that's 2 years.
Subject to.
That's reading the rule in a very different manner. I think.
That's what, Milord, I wanted to clarify, Milord, in this regard.
All because
But
of
this
Sudhir,
rule-
Milord. Because Sudhir said you can't have the exam before.
Exam.
They were forced to enroll them to even make them take the exam.
Okay, they enroll them.
So they
take the
enroll,
exam.
your lordship in that order made a distinction between enrollment for the purpose of examination provisionally as opposed to enrollment for practice, which happens only after passing the
That's the
exam.
point.
That is why, otherwise,
No, then, see, that's the question. So I
Yeah.
wanted to know, we wanted to know and understand. It is being said that they can't file a wakalat. Okay. It is being said they can't therefore plead under their own name. I understood that possibly they can be, whether that is permissible also, not a proxy counsel. Proxy in the sense that, okay, you can take a passover, sometime maybe record your presence, even that would be questionable, but
I can understand. You see, if you go to chapter 4, it's a complete code in itself with regard to right to appear and argue or even appear on behalf of the client.
but problem is.
1 minute, that's in fact 29 to 34 is very clear on that. So chapter 4 is very, very clear. It says, 29 says advocates to be the only recognized class of persons entitled to practice law. 30 is right of the advocates to practice law. Special provisions for attorneys. Power of the court to permit appearances in particular cases. Advocates alone entitled to practice. Power of the High Court to make rules. So this chapter 4 is, in fact, is a complete code. We'll certainly examine what you're saying, what has been argued, whether
No.
in terms of 49, we can permit them to hold pre-enrollment or pre-provisional enrollment examination. That's a separate issue. But let's not forget what is happening today
Yes, yes.
Yeah.
is in spite of
What?
The two-stage enrollment
No, I
process.
thought you.
It's not
you are-
really
so
working.
You're in a rush or you want
Actually,
to
we
go
lost
somewhere. That's why you're.
No,
Take
no.
either path.
My
Pre-enrollment
in-laws
has
went
legislative
outside. They
sanction.
just
Post-enrollment needs an
came.
amendment in the act.
We, let's,
Let's.
Your lordship sees 30.
You are
subject
in
to the
rush,
provision
no?
of the
You
act.
said you had to go
There are other
somewhere.
provisions which say subject to the provision of
No,
act and rule.
we'll come to that. We'll just come to that. But
Yeah,
as far as
I thought.
post-enrollment, two-stage enrollment process which we have adopted,
Sorry.
is it really working? Is it giving us
My lord, that
better results than it was before?
otherwise will be worse off
This
because the
and
exam could never
continuity,
be held.
evening
Correct.
walk,
Because of
you know,
Sudhir.
sitting in
So
sick
if
out
Sudhir
and
my lord
enjoying
is
the
to
evening.
Yeah, that is
take its
very
fate
No,
in
Mr. Srikanth,
important.
what you are saying is, according to you, then Rule 9 on page 739 is without power.
Tell you to that. I'm
This is what
calling
you are saying.
इसलिए call
No, this is
किया just
after
because you
enrollment.
had some doubt. That's what I'm saying.
Yeah, in the morning कुछ corrections
Pre-enrollment is permitted, but
mentor
unfortunately
बोल रहा था
struck down is
मुझे
Sudhir my lord.
ठीक से
So
connect
this
नहीं हो पाई
Bar
बाद
council
में
is not
क्या
able to hold the
पता है
exam.
क्या मैं
Pre-enrollment I can't hold.
जो
Post-enrollment I
enrollment
allow you
claims
to
थे ना
automatically practice.
the original
So they worked out in a
कभी
resolution. They're all right.
बैक स्पेस हो
Enroll,
गया होगा या कुछ पता
Write
नहीं
provisionally, write the exam.
जंबल हो गया
Then
है
we will give
जिगजैग
you
हो
the
गए
full
हैं
enrollment
सारे
after.
उसका
This is a via media
और जो
because of
मेन
Sudhir my lord.
फॉर्म
Rule
तुमने
9
उसमें
will be
सही है
completely
तो
contrary to
उसने
section
पकड़ा
30.
होगा
30.
Yes.
That is the standard.
आर्टिकल भी
No.
नहीं पकड़ा
But my lord,
इन्वेंटर ने पकड़ा
provided, my lord, permit the other clause, my lord, let the exam be
तुम्हें
held
पहले में कुछ
pre-enrollment.
समझ नहीं आ रहे थे
Otherwise, my lord, neither
पहले कुछ भी
pre-enrollment
नहीं समझ
nor
में आ रहा था
post-enrollment all India bar
मुझे
exam.
लगा कुछ स्टेप उसका कुछ मतलब कुछ
It's-
होते हैं ना उनको समझ नहीं आ राजी रेड्डी ऐसा कुछ था हाँ राजी सतुष राजीरी
Best
सतुष
possible method because of Sudhir. When
तो
Sudhir was pending in
मैं
the
बाद
Rajya bench,
में अच्छे से
definitely my lord, your lordship has
एक
started.
तो एक
We'll
लाइन पढ़
examine
के
this, but
दोनों को
we'll
एक
examine
एक
30
वर्ड की
independently
तो
because it
5-6
says
वर्ड्स
subject to the
बैक
other
स्पेस
provisions
हो
of the
गए
act.
Yes.
Again, we'll have to
सिर्फ
examine.
एक
That will have to
छोटा
be
सा
examined in
इसमें
that light.
Once my lord, we
1
show
2
your
1 2
lordship
बोल के
this as
रहता है
the
ना
learned
बता
attorney has
इसमें
shown.
और
49,
उसी को
what is the
मैंने
scope of the state bar council?
रेस्पॉन्स शीट में हर
When does
जगह
bar
वही
council of
वही
India
डाला
come in the hierarchy? Policy is actually
वही
laid down by the
मेन
bar council of
उसका
India. State bar
डिफरेंशिएटिव
council
पॉइंट
does
था
the enrollment and admitting to the register.
पूरा
The scheme of who
पूरा
is
कचरा कर
entitled,
दी
my lord,
थी
so a lot of, my lord, the scope of this case turns on the word
इसने नहीं
entitled, class
पकड़ा
of, classes of people entitled to practice.
क्या नाम है कार्तिक
On
ने
that
नहीं
will be
पकड़ा
encompassed the
अच्छा
power
उसने
to frame a, you know, an all India bar exam rule under 49, you know, AG, 1G. And that is how, you know, Sudhir completely misses it by linking it to 24. 24 is only for the purpose of the state bar council, you know, admitting to the role. So
ठीक
the
है हम
difference
लोग को
between
क्या देगी
admitting to the
बता
role
कोई
and entitled to practice is how, you know, this case, and that is completely missed in Sudhir. So
I went
Sudhir,
to
notwithstanding this, you know, important point which the attorney raised
I
of
had
being
shopping
contrary to
last Sunday.
Anirudh Chulani's case, independently misses the scheme of the act and the express provisions permitting the holding of the exam.
So
I
your
had
case
one
is
earring
that
and one
we should
bracelet
permit,
and
in terms of the
diamond
scheme of the
nose
act,
pin
an
for my
exam
mother.
prior to even enrollment.
Yes.
That will solve every problem.
All problems solved.
Or every
Budget was
problem will be
too
solved.
No, there will be
small.
another problem.
They, you know,
Not all
they
problems
force
solved.
us
You'll have
to
to have a,
take
problem, yes.
schemes,
you'll have to have a
pay
sunset clause.
monthly.
Yes, sir. Now that it is granted.
Because if we were to agree with you,
No, no, no,
what
no.
Yeah.
what in the
And
meantime has
तभी
no,
transpired,
no,
making
the
charges बहुत
transition
मैं
period,
कुछ भी
this
हो जाए
norms
इस
will
बार
have to
मैं
apply for transition period till you implement it. That itself will take at least 3
There is
years.
an exam
So
coming
the-
in November.
हाँ that
All
is
India
also
bar exam
waste.
coming up, I don't know when.
Yes, coming.
The best
Mr. Mishra,
jewelry I
it's
found,
not
you
the
know,
stage of the
Lalita
exam which
jewelers.
is the issue. The
They
quality
don't
of
take
the
making
exam is the
charges.
issue. The
That-
And if
filtration
you
process
take
is the issue.
That they-
schemes,
you
no,
know,
that-
वो
that-
लोग
That is
gradually
squarely within your
निकालते
domain.
हैं. So
That
you
is
pay
within
only
your,
for
squarely within
the
your domain, but for
gold.
various.
आज का गोल्ड का क्या प्राइस है? कैलकुलेटेड इन ग्राम्स जो जितना लेंगे वो.
So we gave
That's
suggestions,
it.
I think, on
That
how
is
to
best
for
thing,
the
no?
Examining it,
ये
you know,
लोग
and on his
पूरी
own lordships
एक साल
took the
दे के
Singapore
ये लोग
model.
फिर
We had only
मांगने को
given the
charges
UK
भी
and the
है.
US.
उसी पैसे से ये लोग
He's
शेयर
taken the
मार्केट में
Singapore
भी
model
घुमा
and
देंगे
I think they're
हमारे
already at
पैसे से ही. और
Are
फिर
you going to
मेकिंग
hold the
चार्जेस
exam
भी
as
लास्ट
per
में
his
लगा
guidance or
देंगे.
you?
This
और इनका
guidance only.
कोई कैलकुलेशन नहीं
Only
रहता.
for
हम
this year they have
लोग
said
जितना
because of
गोल्ड
the
दिए
time limit.
वो कितने
Old
ग्राम्स
silver
में
will
हम लोग
continue,
ऑन
but for the
किए.
next exam,
Nothing.
lordship is going to recommend
हम लोग
the
10
framework.
11
And
महीना
even
पे
the
करो
structure of
and
Everything, you know, as that
अचानक आज
process,
की
as
गोल्ड
we
रेट
said,
करने
difficulty
लगा.
levels,
बहुत
many
मुझे अच्छा नहीं
alternatives
लगा
for
वो।
Read was the
और
hurdle.
उसके पास
They
ज्यादा
have
ऑप्शंस
their hands
नहीं,
were
नॉट
tied,
इवन
and in the
सिल्वर
interest
और
of the
नथिंग.
standards of the
Everything
bar,
is heavy,
they
heavy.
prescribed the All India bar.
That is meaning
Because a
that
committee recommended it.
2.5 lakhs से नीचे
There was a
कुछ
committee
है
will not
नहीं.
appointed the Lord Mr.
पूरा
Gopal Subramaniam
पूरा
headed
वो
it.
दुकान
And he gave a
छापा
detailed
के
report.
हर चीज को
Hybrid
10
via
बार
media.
वेट
By
करके
media. But then what to do when enrollment
have
was
taken
required?
बहुत
What to
छोटे
do?
छोटे.
Then they made it provisional.
That-
This
that's
is all
why
it's
in
not
that
happened.
matter,
उसमें
Mitra said our hands are
3,000
tied.
का
He said,
थोड़ा
okay,
काम
we'll
हो गया.
So
find a way out of interpreting it. Because
Fix
we
this.
couldn't go into the larger issue.
Pre-enrollment will not, will show static
No, yeah.
portions. No, as and when the
And
learning-
therefore, as I said, in a
Oh,
nutshell, you're
लड़कियां
saying is have
you
a
talk
pre-enrollment
you
barring.
keep talking
Correct,
about
sir. Yes,
these
ma'am.
things.
That will
Girls
obviate
are
the
always ready.
requirements for
जिसमें
education.
मिलेगा तो
That is,
उतने
that will
का
give quietness to all the
And the
issues.
training part, they will have to come out with something concrete.
But I understand.
The trainees can't be left to fend for themselves in searching a
I'm not
person to train.
fascinated. No,
They
no,
will have
I'm
to have a
not
scheme.
fascinated.
How they have it, as
After
and when they
marriage,
frame
I
the
have
room,
seen so
they will
much
have to
like
look for it, have
it
a
is
committee,
necessary.
speak to the union
It's
for
not
the funds.
because to
See
become
that
rich
every
or
individual advocate is
something.
getting a person to train and incentivize
Or,
that
you know,
person
they
in whatever
ask
way
you
possible
what your
and ensure
parents
payment
gave
also.
you,
So your
The
suggestion,
exam part
what
cannot is
your
but your
parents
suggestions
have,
we had
these
incorporated in
things,
the
you
orders
know.
for them to consider.
So why to
Consider.
Ultimately,
burden
power
them?
lies
Just
in it. So if
थोड़ा बहुत 10,000
I don't know
20,000
whether just
का
Naveen
ले लो.
Sinha's committee will also look
Plan
into
तो
this
उनका.
or it will not look into it.
No, that committee is different, I think.
That is a different committee.
Not so many ways to incentivize, so including contesting elections for office bearers.
Course
If
being
it is
done
made that you will have to
administrative.
have unions, they can do all that. If they only, Mr. Mishra is
Oh, the girl
cooperative in
next
this,
to
he
me,
other day filed the
the
affidavit in
girl
the court.
next to me
Mr.
is
Mishra will
married.
have to check his
She's
own eligibility
married
then.
earlier than me only.
Office bearers of bar
And
associations,
two
bar
more
Whether he is paying to his juniors or
one
not.
girl also completed MBA and she joined Tech Mahindra 6 months before.
He's a
And
generous man.
my brother, last one,
As far as
who
all
just
India bar is
completed
concerned, we have a
MCA,
committee and we are
written
framing past 10
examinations
years,
in
we are
Iswani
conducting, there is no any
University.
issue. But just I wanted to bring your lordship
Today he
notice.
is returning
This
home,
exam was
so
conducted in the year 2010
वो भी
August.
बकरा बनने वाला
Only
है.
50% alone may not return the exam. Everywhere may not hue and cry, may not all the states. Then thereafter, may not we said no, you have to write. Then may not now within a 2 or 1 year, may not everybody has written the exams. No
Initially,
issue.
there was some
Yours,
opposition to the concept. To
Sometime earlier.
2010 level.
Nobody wants to be accountable. Nobody wants to show
yeah,
what the performance is.
ठीक है ना.
Now, my lord, there is no issue at all. Now everybody is writing, my lord, no issue. And then, my lord, we have to keep in only one thing, my lord, in our mind, because many people are come from the rural areas rather than downtrodden. That and all we have to look into it, and then, my lord, we have to prepare the question papers. Otherwise, my lord, if you
Fine, but just look at it.
yes,
See, when people take the civil services exam,
yes,
extremely competitive exam. People from rural areas, socially, economically backward areas, take the exam. They don't
There
say
is only
prepare.
one question paper, only one.
They don't say give me something else. I should be less than that. Why for lawyers should it happen? The relevant person who works hard enough will get it.
Yes.
What is it?
Sudhir Millard thought State Bar Council was supreme and they were to function, they were to prescribe. Their role is under the overarching umbrella of the Bar Council of India. They prescribe the policy. They will not have to verify.
They enter on the roll because state bars depend on which bar you are enrolled in. The basic verification factor gets done at the state level.
Uniform policy can only be prescribed Bar Council. We have every state has a Bar Council. Their role is and disciplinary powers. If you don't finish in 1 year, it goes to Bar Council.
In fact, as my brother also said, and I hold a view, that a good quality of competitive examination to determine your abilities before you start practicing, whatever stage you actually practice, is an essential thing. If you have to improve quality, this is the only way you will be able to improve quality.
What my Lord mentioned of bringing uniformity, like the Delhi University is now adopting, may not mention that example of the, that's what is it called? There's a new phrase for it from this QET.
QT.
So like that
QT exam.
Equalizes.
So because people used to come from different boards, different areas, levels of marking used to be different. So same thing will occur in, that is of course in terms of further admissions, because the level of difficulties would be different. But here, the man gets right into the responsibility of representing people. And unless you are assured as a bar council institution that he is a man who possesses a requisite this thing, What is the percentage of now? You have increased the pass marks or no?
Now it is 50%. The recommendation of the committee was between 50 to 60. Now it is 50%.
So that the serious practitioner will not looks up studies and then.
So I was just thinking, if the recommendation of the committee is 50 to 60, why do you take the base one? Why not 60?
Or maybe.
Now we'll do it. Now we'll do, the pattern of exam is also going to be changed as per by
You
law.
must change. Like, I don't know whether.
Lordship also indicated, let it be inclusive, not to eliminate. that
Not to eliminate here,
Only
but see.
Negative mark, no negative marking, but I think.
Negative, we left it to them. We didn't say yes or no. We just said negative because it's an objective exam. Unfortunately, you can't have a assessment exam in that sense. So some way it is a mugging based exam, all of them.
Yes.
Because this is the problem with all this. But you can frame the question in a manner where the ability of the person to think is there.
Applied.
As the learned attorney said that you don't have to take the examination reading a Dukhi. So you do something more than that to be able to take the examination. And then the difficulty levels of the vary as a qualifying exam.
Yes.
So suppose you have certain number of questions which are of a little lesser difficulty grade. Then they will have to do it. But to pass, you must be able to solve them and solve some questions at least out of it. You're not ultimately giving whether he's getting 90 or 80, but the benchmark should be achievable by a person who can solve the simple question, at least some of the more difficult answers also. Not give then give grace marks, give other marks, then purpose gets lost.
We are not giving any grace marks in that.
Earlier it was given, you are aware, the grace marks were also given because people were not passing.
Initially, we had to do it in the year 2012-13 just to attract the students because
to come
there
and
was a
write.
large protest by the student, the newly enrolled advocates. That was the, now there is
Now
no
that
problem.
Asking us at least that much system is set.
When do they get the voting right?
That is the main.
I think voting right is also now.
No, they are not the voters.
The
Only
first
have to
five-
succeed the
Those who,
exam.
those who,
After I think you clear the exam, is there not a hiatus period? I think something you have to be in practice. Some of the bars have it. That you must be practicing for 3 years or 4 years before you enroll as a member of the bar association where you will vote.
some
That
of
is
the
only
bar
bar
associations they have.
Not in.
The bars have.
And then we have a display plot in the website, those who are succeeded in the All India Bar exam and separate, and then those who are failed plot, that also we are displaying. So no issue at all.
Manoj, I was trying to point out at page 739 that this prohibition under Rule 9 was made under 49(1) AH. And that, my lord, has stood the test of time from 2010 for 12 years. Now the question is, which is if the power is there under AG, if you have got the power under AH, you have the power under AG. Do you want to have a pre-enrollment examination or a post-enrollment examination of an aggregate? I have pointed out, my lord, the rather unfortunate position if a man practices and then fails. It will be something which one would not like to live with. And therefore, my lord, it is as if he has been dismissed from service, a public servant or something like that. And therefore, in those circumstances, if this power exists, the power under 49(1) AG also exists because both of them are similar to one another.
You are
And
also canvassing for a pre-enrollment bar exam?
Yes.
You are also canvassing for a pre-enrollment bar exam, I'm saying.
No, there is no.
Yes.
Yes, I am canvassing for a pre-enrollment bar exam. Because according to me, my lord, that would be the most appropriate thing. It was in existence, from 1920.
So the only problem is Sudhir's judgment, which says no pre-bar.
Therefore, you say,
Sudhir's judgment is the only problem, Mr. Venugopalan.
Lord, your lordship is sitting in 5 judges. And 3 judges have held whether obiter or not obiter. According to me, it's not obiter. That 49(1) AG will cover the holding of an examination. Now, if your lordship has seen the history of examinations, from 1926 onwards, examination was repeatedly recommended and was being held under the statutes or on recommendations of various committees, law commission. And these were pre-enrollment examinations. They had to wait for 1 year for apprenticeship while doing their apprenticeship. And then, during that period, they undertake the examination. And if they pass, well and good, they are enrolled. If they fail, they again have a right to repeat a number of times. And therefore, that will be the most, appropriate thing. And therefore, with your lordship, this is under attack, this particular examination rules of 2018 in one of the petitions. I say, my lord, that 49(1)(a), 49(1)(a)(g) clearly confers the power to classify the class and category of lawyers. What are the category? The category is one who has got his qualification of having passed the law exam, thereafter may not having passed the examination. And if you provide for a training, you have completed the training. And therefore, in those circumstances, for your lordship now, lords, to refrain from doing what is just and fair. That is, the exam is should not be something post, lords, the whole enrollment of an advocate, but pre-enrollment. It will be the most appropriate thing for them. And this will be the interest of the bar, because as your lordship sees, my lordship, at the end of, there was a question asked in Parliament at page 980 of the volume 2.
Yes.
At Minister of Law, Sri Kiran Rijiju. In the case of the Bar Council of India, in answer to the question, Legal Router so-and-so, Honorable Supreme Court so-and-so has made observations about the desirability, better accountability from law colleges of requisite faculty, monitoring by the Bar Council to ensure that once the law college obtains recognition, it is to maintain the parameters as set out.
Yes.
In ABCD. As regards the yardstick for examination and stringent control of monitoring of law colleges and compliance is concerned, Bar Council of India is informed that in order to revamp the situation, the system, it has earmarked about 500 institutions throughout the country who are substandard, below standard, and team-led by some former judge, senior advocates, noted academicians plan to conduct surprise visits of such institutions found to be below standard, that is having no sufficient number of faculties, then the legal education shall take immediate steps. I was told around 500 have been closed down. And today we have on the right-hand page,
500 institutions have been closed down, Mr. 500 institutions have been closed down.
This is because I was
So the 1700 number is after 500 closed down.
Justice Ahmadi Milad was extremely upset by the manner in which the fly-by-night institutions were allowed to function. And therefore, he said that examine this and find it, according to me, were closed down. Then, Milad, in the 982, Milad, there are 1,721 law schools, with more than twice as many private law schools as public law schools. Therefore, the question is, after these were closed down about 10 years back, how many years back?
This closure, at that time, about 200 colleges were closed down.
200.
Now we have earmarked 500 colleges, and we have sought permission. We have constituted a committee headed by a former judge of the former Chief Justice of High Court for conducting surprise inspections, and we have earmarked some of the colleges nearby this Noida and Ghaziabad and some in Andhra, substandard colleges we have earmarked. And once we get the approval of this honorable court in that Twinkle's case, we'll start that process.
So you have now, what you are saying is, out of 1700 colleges, you have earmarked 500 to close down. Is that correct?
Therefore, my lords, it's a fact of life that there are substandard colleges. How do we then find out from the result of the students which pass out as to whether they maintain standards or not. The only manner is not an examination. An all India examination, uniform, and the syllabus is published in advance. The students will prepare fully, and even then, some of them won't be able to even write one answer. Now, in which case, Milotchi should read out it would help in weeding out Milotchi law school itself. And therefore, in those circumstances, it is essential for maintaining Milot standards and uniform standards throughout the country among law colleges that you should have this examination.
The other petitions, attorney, which have been filed, do they assail this for enrollment examination or they are opposed to pre-enrollment also?
The post, because there is no pre-enrollment exam now.
No, if
Therefore,
they're
the
saying there
post-enrollment.
can be no exam pre or post, or they're saying you can have it pre but not post.
Yeah.
They are all post-enrolled.
They don't want any exam. Milot, my recollection is there was a strike. There was a strike, Milot, all India throughout by the
Yes,
students.
there were problems there.
At that, in 1973.
1973.
In 1973. And it was as a result of that that Parliament voted set Milot to the pressure of the students and then removed this. Otherwise, Milot, how many enlightened Milot institution ever Milot function if Milot you do not have any machinery to find out as to whether Milot is.
They are expressly saying that Sudhir doesn't require reconsideration. And they are challenging the rules for post-enrollment. Because there is now no pre-enrollment, the only question is whether Sudhir is right. They are taking the stand that Sudhir is rightly decided, doesn't require reconsideration.
And if your lordship decides Sudhir is right, then pre-enrollment also Milot cannot, because it's age and age.
If we have to go to a system of pre-enrollment, then it has to be opined that Sudhir doesn't lay down the correct position.
Yeah. And Milot, Sudhir is really, according to me, for insurance because of
Of that, that has to be taken note.
That's my submission.
Thank you.
No, your lordship, excuse me.
Yes, sure. Can we have the benefit of a 3-page note from?
Very well. I'll do that. Much
Thank you.
great.
Great praise, Lord.
Yes,
We are very grateful that your lordship gave me a chance to.
you have been assisting us in that.
Yes, my lord.
We did not let go of you even to assist the bar council when you tried.
Lord, I have, beyond that brief, made a note to assist your lordship in this issue also. Lord, this will also be pruned down. The idea is to give your lordship everything in one place. I'll take your lordship to the errors in Sudhir, my lord. What I feel are the aspects of Sudhir which will not require reconsideration. Your London Attorney General, my lord, has taken your lordships through the rules, the section and the rules. Your lordship, just have my note, my lord, and then I'll give your lordship the overview of what my case is. And then, my lord, place the crucial paragraph.
Need to bundle, hai na? Stiff night. ED's office. Attorney office. Attorney office. He एक सब भी, right? No.
Before your lordship, look at the index at page 2. The stand that I respectfully want to place is that the Act as it now stands permits rules to be framed for pre-enrollment exam. Sudhir, my lord, for various reasons set out in the note, has been wrongly decided with all humility, my lord. The All India Bar Exam post-enrollment, according to me, requires a statutory amendment. But if 1 and 2 are answered in the way that I am seeking to canvass, my lord, the other problem is actually taken care of because there is no need for a post-enrollment exam. As far as training is concerned, my lord, I maintain that though the enabling power is there, in the manner of exercise of power, my lord, there has to be great caution and restraint to be exercised by the Bar Council because the trainees can't be left to fend for themselves. That I'll address, my lord, separately. Just see the index, my lord. I would not burden your lordship with all that has already been placed.
Yes.
How this is structured is, my lord, page 2.
Yes.
There's a legislative history given, my lord, which Sudhir also discusses, my lord, in great detail, my lord, Lordship Justice Majumdar, my lord. The fond memories of appearing before His Lordship in this very court hall. Reports of
Yeah, I share that pleasure with you. I have done the same.
extremely courteous and
Yes.
very
One of the
learned.
most
Yeah.
pleasant persons.
One day, His Lordship dismissed a couple of 4-5 matters for default. The next day, there was a lineup for mentioning more than the lawyers. His Lordship was anguished. Said, "You file the application and restore it immediately." Reports of Law Commission post enactment, case laws on the power of Bar Council. Also has been placed. I want to quickly get to the Roman 4. Roman 3 is just to the extract of what the holding is. I'll just place these propositions, and then go to why Sudhir is wrong, because in that segment, the act is, marshaled and analyzed, and power traced, and the overarching power of the Bar Council is attempted to be demonstrated to your Lordship. Sudhir, says, under the scheme of the Advocates Act, any person who is enrolled as an advocate on a state road acquires an exclusive and unfettered right to practice throughout the territories to which the said act extends. After the 1973 amendment, the deletion of 24(1)(d), any person who fulfills the condition under subsection 1, 2, and 3 of 24 is qualified to be admitted as an advocate on a state road unless she is disqualified under 24 capital A. What was missed, was the opening words of 24, subject to the other provisions of the Act, which takes your Lordship to 49. 49 scheme, is being explained later. Any rule framed by the Bar Council of India under 49 of the Act which cannot be traced to any of its statutory functions are ultra vires because the rule-making powers of the BCA are ancillary powers for discharging its statutory function. It somehow, pegged to 49 with 24 and said 49 will have to operate within the contours of 24. D. It is not one of the statutory functions of the Bar Council of India to lay down conditions subject to which any person may be enrolled as an advocate under the Act. E. From proposition C and D, it follows that the Bar Council of India training rules 95 are ultra vires, the Advocates Act is invalid. Even if proposition C and D are ignored, Bar Council of India training rules did not qualify as rules under AG or AH of 49(1) of the Act. Kindly come to the errors in Sudhir, because this segment I want to place in detail. This is going to be my main submission before Lordship. Kindly come to page 22 of the note, because here the descriptive portions will have to be taken from where exactly Sudhir went wrong.
Yes.
Bar Council of India's powers at a pre-enrollment stage are not ousted through amendment to 7A of the Act. Ideological underpinnings of the role played by the Bar Council of India vis-a-vis the State Bar Council. This is an important area, which your Lordship will have to flag. Under the Act, what is the role assigned to the State Bar Council? When does the Bar Council of India come in? And once we have this perspective in mind, the answer to our question automatically follows. Bar Council of India cannot be undermined. Their role is not subservient to the State Bar Council. State Bar Council has a very limited role, and that is clear, on the reading of the conspectus of the Act. The Honorable Court in Sudhir has, while identifying the roles and functions of the State Bar Councils and the Bar Council of India under the Act, specifically rendered a finding that while the former has the function of maintenance of roles under the Act, the latter is not concerned with the same. Consequently, it was the opinion of this Honorable Court that the Bar Council of India could not prescribe any pre-enrollment conditions, since the function relating to the roles are found to be vested with the State Bar Council. The reason why we say it's wrong is at para 44. It is important to note, based on reading of Advocates Act as to the specific terminology used in different sections of the Act, and to call out the underlying meaning of each of those terms. 6A prescribes that the state bar councils, not functions of the state bar councils are in 6, are to admit persons as advocates on its roll, while 6B stipulates that the state bar councils are to prepare and maintain such roll. 24(1)(e), read with 28(2)(d) of the Act, empower the state bar councils to prescribe conditions subject to which a person may be admitted as an advocate on any such roll. Therefore, a plain reading of the above mentioned provisions indicates that the functions of the State Bar Council relate to maintenance of rolls and admission of persons as advocates on its rolls, prescribe conditions as to what documents they will produce, etc. In stark contrast to these functions given to the State Bar Council, the rule-making power of the Bar Council of India under 49(1)(a)(g) of the Act clearly relates to prescribing rules to specify which class or category of persons, will not mark these important words, will not would be entitled to be enrolled as advocates. The scope of the Bar Council of India's power under the Act is therefore in relation to determining the entitlement to be enrolled as advocates. Then, my lord, we see the difference in words and phrases between, my lord, enrolled, entitled. In this context, reference needs to be made to the meaning of the terms conditions, enroll, and entitled to understand the true import of these provisions. Ramanatha Iyer's advanced law lexicon, the above mentioned terms are defined in the following manner. Condition, thing on whose fulfillment another thing or act is made to depend. Condition is a restraint or bridle annexed and joined to a thing, so that by the non-performance of not doing the party, the condition shall receive prejudice and lose, it should be LOSC, by the performance and doing of the same. Enrollment. Enrollment in English law is the registering or entering on the rolls of Chancery, King's Bench, Common Pleas or Exchequer, or the Clerk of the Peace in the record of the quarter sessions of any lawful act. Enroll, enlist, register, record. Enroll is generally applied to the act of inserting names in an orderly manner into any book. Enlist is a species of enrolling applicable only to the military. Enrollment is an act of authority. Underlying portion, to enroll and register both imply writing down in a book, but the former is a less formal act than the latter. Entitled, to give a claim, right or title. This is what, my lord, is entitled, which is prescribed in 49(1)(a)(g). To give a right to demand or receive, to furnish with ground for claiming. The interpretation is in each case a question of construction and no definite rule can be laid down. Entitled to, expression entitled to occurring in 38 of the Act would mean that a person has acquired certain characteristics to enable him to be a member of any of the bodies of the university. In the case of elections, the entitlement would be only mature on the person being duly elected. Reading the above mentioned definition with the functions entrusted with the state bar councils and the powers vested in the Bar Council of India, the spheres in which both these bodies function become clear. The State Bar Council being tasked with the function of enrolling persons as advocates would mean the act of inserting names in an orderly manner in the register maintained by the State Bar Council, and any condition to be specified by the State Bar Council would be a thing which needs to be positively fulfilled in order for the State Bar Council to then proceed to admit the person on the rolls. This could mean either conditions which are in the nature of forms to be filled, documents to be provided, or in relation to the prescription that a person must not be in employment at the time of seeking enrollment, on fulfillment of which the State Bar Council would undertake the act of inserting the name into a register. Whereas, in the case of Bar Council of India, Section 49(1)(a)(g) of the Advocates Act, this is expanded again, empowers the Bar Council to prescribe rules that would prescribe a class or category of persons who are entitled to be enrolled. Meaning of entitled as set out above would indicate the Bar Council of India could prescribe such condition which could give the right or claim to a person to be enrolled as an advocate. This therefore implies a power for the Bar Council of India, which exists in consonance with the powers and functions of the State Bar Council and could be exercised to prescribe conditions that would have to be satisfied in order for a person to obtain the very right to be enrolled. I have developed, doctrine of incidental ancillary a little later, on how ultra vires, is to be understood in the context when a power is conferred. It is encompassing, all the incidental ancillary aspects of the meaningful exercise of that power. Sudhir Court failed to consider that subsection 1 of 24 is subject to the other provisions of the Act and the rules. Your Lordship sees 24, the opening parts. The traditional lawmaking can either have a non-obstante or a subject to. 24. And what is the meaning of subject to the provisions of the Act? That means, my lord, this will cede to other provisions of the Act, like, my lord, 49, and rules made therein, subject to the provisions of the Act. It is not notwithstanding, my lord, anything contained. Subject to, my lord, we have given case law on what is subject to. Kindly come back, my lord, to the note, para 48. Having considered the theoretical underpinnings of the functions vested in the State Bar Council and the Bar Council of India, it is then apposite to refer to some of the major reasons why Sudhir for holding the training and examination cannot be provided at a pre-enrollment stage by the Bar Council. In concise terms, the reasoning reads 24(1)(d) and 28(2)(b) of the Advocates Act empowered the State Bar Council to provide for pre-enrollment training and examination. The power to frame such rule was subject to approval of the Bar Council of India. This specific power entrusted to the State Bar Council has been repealed through the amendment of Act of 1973. Citing, they also give a reason that the same was not required in view of the 3-year law courses in the country. When such a power was vested in a body and thereafter repealed, the Bar Council of India cannot claim to have had the power to hold. This is what Sudhir said,
Yes.
The findings of this honorable court based on a reading of the provisions of the Act that existed and the amendments made therefore required to be addressed on a wholesale reading of the Advocates Act. Firstly, 24(1)(d) of the Act, which prior to the amendment of 1973 prescribed a pre-enrollment training and examination at the behest of the State Bar Councils, must be read with the opening words of the said subsection itself. 24(1), the Act opens with the words subject to the provisions of the Act and rules made thereunder, thereby making the conditions under 24(1) and its subclauses directly subject to the rules framed under the Act. As held by this court in Ashok Leyland, there are a number of other cases. Term subject to means that it is subordinate or subservient or to be governed or affected by whatever is prescribed. That the provisions under 24(1) of the Act are subject to the other provisions of the Act, and in particular the rulemaking power of the Act under 49 of the Act, is clear from a reading of the very opening words, and this is then fortified by the opinion of this court in Satish Kumar Sharma versus Bar Council. This court categorically held that enrollment under 24 of the Act is subject to the rules framed by the Bar Council of India under 49 of the Act, even if no rules were framed under 24(1)(e) or 28(2)(b) of the Act. Para 9 of this judgment will not be significant, that 49A will have to be still followed, 49(1), notwithstanding 24(1)(e) and 28(2)(b). Secondly, in the light of submissions made in the heading immediately preceding, the present heading, we have one comment on this deletion of 24(1)(d). Actually, it made sense deleting nowadays. There are a number of state bar councils. Each could have had a different pattern of examination.
So the uniformity would not,
Uniformity is defeated.
it's like having the problem which CUTE is trying to cure, which is different board exam with different levels of difficulty.
Though the ostensible reason given as noticed in Sudhir, in fairness to Sudhir, I have to point out, original 2-year law degree courses became 3-year law degree courses. So they said, why now have a training again or an exam again? But
I possibly even underlying pinning could be the how it would work out.
Can you imagine? So Prabhakaran will have one set of rules in his bar council. The other states will have their own set of rules.
Mr. Mishra and Mr. Prabhakaran will have the same set of rules.
That's true. So
They have had meeting of mind on many issues.
yes, and that will is taken care of if this power is left to the Bar Council of India.
Apex body.
Apex body, they prescribe the power, all of them implement it, and there is one uniform. Otherwise, it would have been chaotic under 24(1)(d). Though it got deleted for some other reason, there is strong logic behind it. We will, in the 3-pager mention this uniformity, because this could, while revising it. Secondly, para 50, in the light of the submissions made in the headings immediately preceding the present heading, court's rejection of the nexus between 24(1) and 49 based on the fact that Bar Council of India had no role to play in imposing pre-enrollment conditions does not hold water. The Bar Council of India is clearly entrusted with the rule-making power to prescribe those persons that are entitled to be enrolled it is humbly submitted that 24(1) of the Act and its opening words would make the section and the conditions leading up to attaining the right to be enrolled subject to the rule-making power under 49 of the Act. Thirdly, it is submitted that even assuming that the Act prior to the amendment of 1973 had empowered the State Bar Council to prescribe training and examination, it does not take away the power that is vested in the Bar Council of India under 49 of the Act. Assembly submitted that the legislature is not expected to have any superfluous provision that the Lordship will not construe any provision as OTOs or rogatory, that specifically empower the Bar Council of India with this specific action regarding pre-enrollment training and examination with the purport of 49. Though, my lord, the words used are classes or category of person entitled to be enrolled. While construing that, my lord, your Lordship will grant it those incidental and
You are saying classes and categories will include the prerequisites to be so.
prerequisites as part of the incidental power.
Therefore, you can prescribe the pre. That's how I understand it.
Yes, as part of the incidental power. And there are case law on incidental and ancillary power under the rules of construction. We have cited it, and some English cases which have reiterated it. Other, you don't readily infer ultra vires. You start with the presumption, even in subordinate legislation, that it is intra vires.
Any legislation, you will try to see that it is sustained as long as it is sustainable.
In substantive law, your Lordship will say constitutionality. Here, it's intra vires. There, your Lordship will grant all the power because everything cannot be specified. So, you grant the power and that will encompass, it will envelop within itself such of those accidental, ancillary to further the objects of the Act. It's not something alien to the Act. We are only trying to improve the standard. Who is entitled to enroll, and they say you now take this exam. That cannot be, and Mr. Rao who appeared for the Bar Council. Canvas this 49. Your Lordship will see from Sudhir. Not that, this is all what we are doing. We had canvassed it, in 1999, Sudhir was arguing. Fourthly, it is submitted that while assuming that the Amendment Act of 1973 did take away the express power vested in the Act for holding of pre-enrollment training, it would still not take away the overarching rule-making power that is vested in the Bar Council of India in this regard. Context may be given to the introduction of an examination and the very act of repeal of the same. In the All India Bar Committee of 1953, it was recommended that the uniform minimum qualification for admission to the role of advocate should be a law degree of at least 2 years of study, at least, of law, followed by 1 year apprentice course in practical subjects, followed by examination in these subjects. We have put the Attorney General's compilation below. The Attorney General was gracious enough to make his compilation available yesterday to us. The functions recommended for the State Bar Councils by the committee also read as follows. Power to provide and make arrangements for imparting legal education, holding examination and training of advocates under the directions of All India Bar Council. There is a very interesting passage in the early pages of the note. I just digress a bit and go there for this reason. Page 6. Page 5, your Lordship sees. Something, which is a practical insight to this. Your Lordship may continue with 26, but just digress and go to page 5 of the note.
Yes.
While the Advocates Act of 1961 was yet to be tabled in the Parliament, the Law Commission of India in the 14th report on reform of judicial administration sought to endorse the views of the All India Bar Committee and further provided insight into the considerations that led to the need for a central legislation for advocates. Committee noted that every student of law must, after a 2-year study in university, have a practical course in law to be imparted by the Bar Council. Thereafter, in the context of law examination to be conducted at the end of the practical course, the report stated the following, which is of significance even today. We have already recommended, that is at the Attorney General's compilation, page 107 at 110. We have already recommended the division of legal training into 2 years training in the principles and theory of law to be imparted in full-time institutions and a year's practical training to be imparted under the direction of a body of professional men. At the end of the university training of 2 years, the law graduate will have to decide whether he wishes to embark on an academic career to research in law or a professional career through a practical training in law. A practical training is as essential to the making of a professional lawyer as through academic training, as a thorough academic training. The matter has to be picturesquely put in the following words by a writer. All the theory in the world ill equips the lawyer who has all the legal lore at his fingertips, but doesn't know how to draw a summons, a will, a deed, or a bill of sale. Law schools furnish their graduates with new, shiny, potent tools. Unfortunately, the average graduate has as little knowledge of how to use them as a 2-year-old child has of how to use a blowtorch. Perhaps Chief Justice Vanderbilt had graduates of this kind in mind when he observed that law school should be concerned not only with the principles of law, but with the know-how of putting the principles to work. Law schools of the country cannot continue to lag behind the engineering and scientific schools with their laboratory work or the medical colleges with their clinics. It is not right that young lawyers should learn the skills required in the profession at the expense of their clinics. But I'm sure Mr. Mishra will work out an arrangement for the training without prejudicing the trainees and allowing them to fend for themselves.
Earlier, it used to be a 2 years law course with proficiency. It's called proficiency itself. 1 year proficiency, 2 years law course.
And your lordship is right. In the early 60s, I understand, Lord, you have to pay to join a leading firm of solicitors. Pay the other.
That dynamics has completely changed. Dynamics, as Mr. Gopal said, that it's not the course of last refuge. For many, it's the course of the first option.
First choice. First choice. And there are law colleges have day zero where the placement happens and then they are picked up. All the national law schools have more than 60, 70 students in every batch being picked up by corporate and in the litigation of big law firms. 53, page 26. Kindly come back to 26. Because we are still analyzing the scheme of the Act. Thereafter, the 14th report of the Law Commission of India on reform of judicial administration. Commission specifically approved a 2-year study at a university followed by a practical course in the law, which will then be followed by an examination. The specific context requiring an examination and training as a power specifically vested with the State Bar Council is that university education was to be for 2 years, followed by a specific 1-year training and examination to further equip a graduate with the skills required to be an advocate. This can be read to be part of the intention to have a thorough legal education for candidates, given the yearly structure that was proposed for the candidates. It is therefore in this background and context that the State Bar Councils were vested with the power to prescribe pre-enrollment training and examination. Submitted that in this light, the repeal in the year 1973 is also to be considered. Requirement for a 1-year training and examination in order to equip a graduate with the skills while he was still part of the education system was found to be necessary due to the 3-year law course introduction as a consequence of the power of the State Bar Council. Then, having considered the context in which the above mentioned examination was to be conducted, humbly submitted that this examination was specifically brought into the Act to be part of the legal education curriculum of a candidate, having found to be unnecessary based on its linkage to the duration of the course, would not in any manner restrict the overarching power of the Bar Council under 49(1)(a)(g), which empowers the prescription of a condition that would entitle. The Lordship can skip because that point is made. 55(24) capital A is misplaced because that is power to disqualify a person from enrollment. It is materially different from prescribing condition. This is Majumdar adverts to this clause to say that it is not even part of 24A that a person who has not taken the exam would be disqualified. Then on incidental and ancillary power, kindly come to para 57. There can be no quarrel with the proposition emerging from the judgment in Sudhir in view of the opening words of 49(1) reads, Bar Council of India may make such rules for discharging functions under this Act. Your Lordships have always held that the opening words in a rulemaking clause have its own potency and power as long as it is for discharge of function. And the enumeration is only illustrative. Kindly see 49(1). 49(1). When you say in particular or including the following, the opening words below are all encompassing. As long as the rule is enacted for furthering the object of the Act. The Bar Council of India may make rules for discharging its functions under this Act.
Bar Council of India may make rules for discharging its functions. The power of enrollment is not with the Bar Council of India.
Power,
Power of enrollment is with the state bar councils.
power to fix the criteria.
Correct. That is something different.
Yes.
But power of enrollment,
That is true. The formal enrollment is not.
the power to enroll is with the state bar councils. And that may be the reason why they had said initially that the power of training and examination will be with the state bar councils. Now, in that light, now read the powers.
Now, Miller. In particular, such rules may prescribe. Kindly come to A, G, Miller. Shall I place the entire scheme?
No, that's fine.
The class or category of person entitled to be enrolled as well. That is not so. While it is true
We
that
have to give the only way to accept your submission is to give an expanded notion to AG.
AG.
When we give the class or category of persons entitled to be enrolled as advocates,
there is a legal principle why
please correct me if I'm rephrasing what you are saying. That this expression class or category of persons would include the class and category of persons who have cleared the pre-bar exam. This is what I
and you know, there is a legitimate legal jurisprudential basis which comes to the next point.
Just one more thing. You see, ultimately, if we hold that your right to practice depends upon your clearing the bar exam, whether it's pre-enrollment or post-pre-enrollment, ultimately functions and performs the same of.
Except that post-enrollment, that 30 comes in the way. I have dealt with it.
That we'll examine.
But pre-enrollment will not, subject to what your lordship says.
Your submission is the correct and simplest method is to provide a pre-enrollment examination to obviate all these possibilities. And therefore, if the expression is shared in 49 are taken to include while enrollment, then that would subserve the purpose.
And how do we will not invoke any principle to include that? You know, kindly see the Kargar Panchayat. I'll read page 28, para 58, and then will not come to this doctrine of incidental and ancillary powers, a well-known rule of construction in administrative law. However, page 28, para 58, in applying this principle to the Advocates Act, this Honorable Court failed to consider the BCA training rules could be traced to the BCA's function of exercising general supervision and control over state bar councils under clause G of 7.1 of the Act. There is also this power that 7.1, when it deals with the functions of the Bar Council of India, it says supervision and control. 6 deals with functions of the Bar Council of the state. Functions of Bar Council of India. 7.1G. Shall be to exercise general supervision and control over state bar councils. I am not suggesting to my lord that we have to do an overall reading of the Act. If the object of the Act, see the specific provisions, then we not see whether classes and category give a legitimate basis for construing that the Bar Council of India can prescribe an All India Bar exam. Lord, kindly come back to 28, Milord. Line about 3, 4. Secondly, this Honorable Court erred in interpreting 7 of the Act as a provision which exhaustively lists the BCA's statutory functions. Why do I say so? Because 7, Milord, before your lordship do away with 7. Kindly see, Milord, H, this 6, 7, yeah. L, Milord, 7L also. To perform all other functions conferred on it by or under the Act. To do do all other things necessary for discharging, to perform all other functions conferred on it by or under this act. By the act is, Your Lordship knows, by the provisions themselves, or under the act, Your Lord, will also include the rule making, Your Lord, power. Kindly come back to 28, Your Lord. Thirdly, it is submitted that an additional
एजी में ले आ रहे हैं ना बार बार कैटेगरी ऑफ
this kind of scenario.
Mr. Anand, we have a special bench at quarter to 4.
Resume tomorrow.
Continue tomorrow.
Wait.
I'll partner.
वो जो रिजेक्ट वाला है ना
142 बैटरी मुझे लगा है।
कल मैं अनूप जी को कल सुना जाएगा देखा नहीं लेकिन मैं
कोई ना एप्लीकेशन डालने को इंक्रीडिबिलिटी
टीपी में एप्लीकेशन मैंने कि हाँ 142 की पावर एक्सरसाइज करना वो पोस्ट करना 142
It should be.
Why should you?
Press on पचास लगा देते हैं.
सुनाओ 2 मिनट सुन लेंगे इनको वैसे ही.
Who is appearing in this application?
You might be making a mention tomorrow.
He mentioned it. When he mentioned we'll deal with it.
May I just ask that your lordship should submit the written submissions in advance or during the course of the hearing, whenever lordship's turn comes tomorrow after.
You are, I take it, are you opposing
What your lordships, the amicus here is suggesting, we're opposing the bar exam which is in current existence. We're not opposing a pre-enrollment bar
So
exam.
you're okay with pre-enrollment?
Yes, your lord.
That's fine.
Yes, your lord. We are all done, I think.
Actually, I think everybody is saying pre-enrollment. Is there
Yes,
somebody
yes.
opposing even pre-enrollment, I want to know?
The only
No,
only thing is whether the V Sudhir will not, because V Sudhir is directly on this point. That
We are
is-
considering,
Yes,
that's why the position bench is considering this today. So therefore, we take it that everybody is advised that pre-enrollment exam should be.
Yes,
Which can only happen if we modulate Sudhir.
yes.
That's all that is there.
just certain points with regard to the pre-enrollment examination.
And now,
Modality.
you point out if we want to listen to you on something.
Yeah.
If you are supporting pre-enrollment exam, there is no point in duplication of arguments.
Is your stand something contrary to what has been argued till now?
Lordship,
Say yes or no, for you to decide, not for us to decide.
lordship partly.
Okay.
Then you will have to see what that partly is for us to know. Thank you.
Nine.